All right, we'll go ahead and get started. As you can see, we're missing Chair Ward tonight, and due to the fact that the previous vice chair was not reappointed at the last city council meeting, it's kind of up to you all to open this meeting up. So I will put it on y'all for a motion and a second to kind of run through that. So I'll let y'all open the meeting up, and then we'll discuss the aspect of appointing a temporary chair for tonight's meeting to open up the business for the Board of Adjustment. So.
Well, it seems like everybody's looking this direction, so I'd like to call the meeting of the Graham Planning Zoning Board to order.
Will you make it in the form of a motion, Mr.
Oh,
Bennett?
I'm sorry, yes.
I'd like to make a motion.
Make a motion that we call the meeting in order at 6:30 PM 18th. Do I hear a second?
I second.
All in favor, say aye. Opposed?
I got you. So at this time, as I mentioned, we're missing out on our chair and vice chair. So again, it's up to you all. After we've opened this meeting up as Board of Adjustment, you all have to elect a temporary chair to run tonight's meeting. I do have, so don't be too, I guess, scared to kind of operate under it. I do have a script for whoever kind of falls in line with that tonight. And also, while we're on the topic of, I guess, new things, is we have Mr. James Stockert here as well, who was appointed at last week's city council meeting. He'll be acting as one of the alternates on the Board of Adjustment moving forward, but a member of the planning board. So if you all welcome him as well. So welcome, Mr. Stockert.
Okay, gentlemen,
I'll make a motion at this time to allow Mr. Benesh to be the temporary chair for tonight's meeting.
And I'll second it.
there is a motion on the floor. Say nay, but go ahead. You guys have had pretty much decided on that. So all in favor, say aye. All opposed? Looks like I'm it tonight.
Congratulations, sir. They have to worry about that part too much because we got that taken care of. We go through that. Stop right here.
Okay, you'll read that?
Well, I'll bring it up.
Okay, fair enough. Well, I would like to call the planning board zoning and zoning board meeting to order.
Mr. Benes, sorry to stop you, but this is the Board of Adjustment. We're operating as right now. I apologize.
Oh, I'm sorry, you skipped that back the other way. All right. I will now call on the Board of Adjustment meeting to order at 6:34 PM. Approve the minutes from the June 20th, 2023 meeting, Board of Adjustments. Are there any corrections? If there are no corrections, I will ask for a motion in a second.
Mr. Benesh, I motion that we accept the minutes of the meeting of the Board of Adjustments.
Do I hear a second?
Second.
Mr. Benesh, may I be excused since I was not present at that meeting from voting at this time?
Well, certainly, sir. Yes.
You're an alternate as well, so you're not technically a part of the board tonight. So.
All in favor, say aye.
Aye.
All opposed, say no. There is a bit of duty that I would like to ask if everybody would. We generally do this during the planning and zoning meeting. I would like for everybody to rise and say the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Mr. Chairman Benesh, could I ask for some clarification? I don't understand, the planner has mentioned now twice that Mr. Stockard is not a member of the Board of Adjustment. I wasn't aware that there was a distinction.
Why's that? Well, the members of the Board of Adjustment are only made up of 5 people. So the planning board 7 and the Board of Adjustments 5 with 2 alternates that also sit on the planning board. So with the new appointment of Mr. Stockert, that falls them into the
And so who are the two?
the 2.
It's Wooten and Mr. Stockton. Okay, thank you.
Move on to introduce the variance.
Yes, sir. So, do you want to go ahead and,
Chairman Benesh, if I may, I am the presenter for the case for the Board of Adjustment to hear. So I would ask that the Board of Adjustment consider allowing me to recuse myself from this hearing so that I may present the case to you all.
Mr. Huffines are you the planning engineer for the project? And he is working as a planning engineer for the project that this variance is for, so he's asking permission from the board to recuse himself. I would like to poll each one of you if you are in favor or not. Favor. Do you need a motion? Just a motion.
I'd like to make a motion that Mr. Huffine be recused from this vote, from this session.
We have a motion that Mr. Huffines be recused from this. Do I hear a second?
If I understood the earlier discussion, Mr. Wooten is not a part of the Board of Adjustment, so he would not be able to make a motion.
well, he's one of the alternates for Chair Ward tonight who is absent.
Don't we have to? Last time we had to bring people in as alternates, didn't we?
Mm,
Just for clarity.
No, I'm right there with you. So,
Do you want to do the swearing in first?
I guess you can move forward with recusing Chad and then we can go from there. So we'll act your motion out and kind of move forward. So. And then we'll bring you in on the discussion for the variance here.
So you want to back up on the recuse?
Yeah, continue with the recusal, but get a motion from somebody other than Mr.
Okay.
Wooten.
I'd like to make a motion that Mr. Huffines allow himself to be recused for this motion, please.
Have a motion that Mr. Huffines be recused from the board because of his position. Are there any, do I hear a second?
I'll second.
All in favor?
Aye.
All opposed? Motion carries. Thank you, Mr. Huffines.
Now, as we stand, if you all would like to introduce Mr. Wooten into the Board of Adjustment for the vacancy or absence of Chair Ward, you definitely can.
Okay, we do need a person from the alternate to be elected, or I guess you would say proposed
Yes, sir.
to fill that position for tonight's meeting. Mr.
John Wooten.
Wooten? Would you,
If you'll put that in a motion, just motion to bring him on. board
Okay.
as the alternate.
all right,
I'd like to make a motion that we bring in Mr. Wooten to be who's an alternate to be on the Board of Adjustments for tonight's meeting in place of Chairman Dean Ward.
all right, I have a motion on the floor to accept Mr. Wooten as an alternate on the Board of Adjustments. Do I hear a second?
I'll second.
All in favor?
Aye.
All opposed? Motion carries.
Mr. Chairman, there are 2 vacancies. Don't you need another alternate?
Well, Mr. Huffine is an ETJ member, and as it states in the Board of Adjustment, we can only replace city members with city members. And we do not have another ETJ member to represent Mr. Huffine's vacancy. So that is the reason why Mr. Huffine's seat cannot be brought in, because we do not have another ETJ member.
But I was under the impression from an earlier discussion in an earlier meeting that you need 5 members. Is that not correct?
You need 5 members to get a supermajority of an 80% vote, which is the 4/5. Without the presence of the 5th member, then you have to have a full 4-4 vote, as was mentioned from the beginning. So technically, when you were present at the first meeting, we could and have, I guess, moved forward as it stood, but we weren't quite aware at the time until after the fact. So that's why we're here today. Thank you, sir.
I clear that up, Mr. Moon. Then we'll move with the attorney to read through the quasi judicial procedures.
Okay. This is the opening statement. This hearing is a quasi judicial evidentiary hearing. That means it's like a court hearing. State law sets specific procedures and rules concerning how this board must make its decision. The rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must make its decision upon competent, relevant, and substantial evidence in the record. It is a decision that must be based on the standards in the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. This meeting is open to the public. However, participation is limited. Parties withstanding have rights to present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the local government, and individuals who can show they will suffer special damages. Other individuals may serve as witnesses when called by the city council. General witness testimony is limited to facts, no opinions. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include predictions about impacts on property values and predictions about impacts to increased traffic. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they base their expert opinion. Inadmissible evidence is deemed objected to. Any documentary evidence that is certified from a recognized professional source will be admitted without authentication. And witnesses must swear or affirm their testimony. At this time, anybody who's going to be a witness, if they could come forward and swear or affirm.
You swear and affirm the testimony you're about to give today is the truth, the whole truth, and nothing but the truth.
I do.
Mr. Chairman, you can poll the board for any bias or fixed opinions, conflicts of interest, or ex parte or undisclosed ex parte communications or site visits.
Are there any members currently serving today have any issues or communication or any reason to be excused from the participating in this hearing?
No.
Mr. Cameron, can you give a preliminary statement of this request, sir?
Yes, sir. As you all have in your packet, this is a request by Edmund Larcy of GFL Waste Industries at 703 East Gilbert Street for a variance from Development Ordinance Section 10.245 front setback reduction for an accessory structure. And having heard all the evidence, arguments presented at the hearing, I have drafted up findings of fact and conclusions of law that you will find below. A note that these findings of facts were prepared by staff here and should be modified by the board as it sees fit. The property that is subject to the variance request, as I mentioned, is at 703 East Gilbert Street, G-Pen 888-44-09335, and is zoned heavy industrial I2, and you can see that in the exhibit of the zoning map in your packet. The property contains a non-conforming warehouse building and storage yard for trash services. It also contains an accessory structure which was erected without a site plan or building permit approvals. I should note that it states that the warehouse is non-conforming, but they did get granted a variance for that building in the past. So that is conforming according to what the variance states that they got back in the nineties. I'm not sure exactly the date. Number three, the minimum front yard setback in the I2 zoning district is 100 feet as shown in section 10.245 of the City of Graham Development Ordinance, as you can find in Exhibit 2 inside of your packet. The accessory structure is located 87 feet from the front property line, according to the site plan provided by the applicant. This is less than 100 feet required by the development ordinance, as you'll see in Exhibit 3 and the table or the height yard table. The application for variance was filed with the planner on April 24th, 2023, and the applicant provided a site plan showing the location of the structure and notes the converging easement and building lines act as a hardship in this request, as you can see in Exhibit 3 and 4. And as I mentioned, as we move through, we'll jot down any additional finding of facts that may come up that either the applicant will bring up or anything else that may arise. So as we move forward, I guess we can go through the conclusions of law of what planning is found here. Again, these conclusions of law were provided or prepared by staff and should be modified by the board as it sees fit based on the discussion we have. The application for variance in case number VR 2301 is properly before the Board of Adjustment, who has jurisdiction to hear and determine this application. The Board of Adjustment, as constituted at the hearing, is a fair and impartial board without conflicts or ex parte communications. Variances from zoning requirements can be allowed by the Board of Adjustment for the reasons set out in section 10.972 of the Graham Development Ordinance. Those list out as necessary hardships that result from strict application of the ordinance, and it shall not be necessary to demonstrate that in the absence of the variance. No reasonable use can be made of the property. And staff's comment is that under the strict application of the ordinance, the property owner would have to tear down the structure and reconstruct / move the structure about 13 feet from the current location based on what the current ordinance states. And the lot size of the site plan according to the site plan provided is 225 feet by 664 by 30 feet. Moving on, another aspect of the hardships is that results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or general public, may not be the basis for granting a variance. What was noted by staff is that the size of the lot is large enough to house the building within the required setback lines. Another hardship note is that it did not result from actions taken by the applicant or property owner. The act of purchasing property with knowledge of that circumstance exists that may justify the granting of variance shall not be regarded as self-created hardship. And staff notes that the structure was erected prior to any planning or inspections reviewed. And lastly, the requested variance is consistent with the spirit, purpose, and intent of the ordinance such that public safety is secured and substantial justice is achieved. And staff notes that the request will permit a structure within the required yard front setback. Based on that, I have nothing further. And as I mentioned, all these were draft prepared by staff. And if you all have anything to add, we will continue to write those down throughout the meeting.
Thank you, Cameron.
Yes, sir.
Well, basically, we have all witnesses that will be speaking written or have their name completed with their addresses, and they have been sworn in, correct?
Yes, sir.
The applicant is here.
Mr. Benesh, you may want to just make just open the public hearing, just so that everybody knows that it's open.
Okay, at this time, I'd like it to open the floor up for public hearing to hear comments from the
Testimony.
public. And first on the list here is the applicant himself. If you would, please state your name for the record
Edmund Larcy,
and your address.
703 East Gilbert Street, Graham, North Carolina, 27253.
What was your last name again, sir?
Larcy, Larsey.
Thank you, Mr. Larson. If you would, go ahead and proceed.
So I'm with GFL Environmental. We've been based out of Gilbert since 1990. We have a building, but as we grow, we don't have room for expansion for our employees, a place for them to store their food or their boots after they come off the road. Currently, they are using the break room to do that. It's not sanitary, so to help them out, we bought a small trailer for them to use as a storage to keep any personal items they have. So we placed that on that property, but there's no other place to place it. Currently, where we have it is all we have because we have truck parking and trailers over there already for storage, for tools, for our mechanics. So this is the only option we have. After we requested the permits, we informed that during the process that it needed to come back. Well, the ordinance calls that need to be stepped back 13 more feet. We hired Mr. Huffine. I'll call him here. He might have more expert information to share with you why we are not able to sit it back further to what the ordinance call for, because it will cause so much hardship. And then based on the criteria for variance, we believe that we meet those hardship variance. So we ask the board to consider our variance request to allow the trailer to be stationed where it is, to allow our employees to be able to use the trailer for storage at this time.
Thank you, Mr. Larcy. Mr. Huffines, is that correct? Okay.
Yes, sir, Mr. Chairman. My
Yes.
name is Chad Huffine, 505 East Davis Street, Burlington, North Carolina. Mr. Larcy and GFL hired our engineering firm to help them with this site plan, which has evolved into a variance request. So if I may approach you and hand up a few items for you to follow along with me as I present the evidence we present to you in this case.
Please. Yes.
Thank you, sir.
Cameron, let's put if we could put the full site plan up while I begin. So go to the flash drive contents. I think there's a large drawing that'll help everybody get familiar. So while Cameron's looking for that, Mr. Larcy contacted our office earlier in the spring of the year with an interesting difficulty. They had purchased a modular unit to locate on the waste industry's property for the uses Mr. Larcy explained to you. At the time he purchased the trailer or modular, did not know that a permit was required. Cited the modular unit on the property and went through the process of connecting to water and sewer services on the property, at which time it was brought to his attention that a permit was required. So Mr. Larcy immediately began that process. During some of the inspections, it was noted that the modular was situated in an area directly beneath some overhead power lines. Those power lines are within an easement, which runs parallel with the western property line. Mr. Larcy then hired our firm to help him resolve this, come up with a solution and resolve this situation. So what I would like to present to you is our findings, the location of the modular as it currently is located, the proposed location, and the facts that we have discovered during our research for the project. So if I may, Mr. Chairman, I have
Sure, please.
one more document I'd like to bring up. Let you each put that. So now that you have an idea of where the modular is currently located, the solution we've arrived at, which we feel is best for the waste industries facility and minimizes the effect on existing town ordinances, basically rotates that modular 90 degrees. So we have presented that to you on the sketch you see. There is a white rectangle just west of the existing office building for GFL. You'll see it just to the left of a diagonal dash line that cuts through the, thank you, Cameron, that cuts through the white triangle, white rectangle. Do you see that? So where Cameron's hand is hovering is the location we propose. That location directly conflicts with the front setback published in the City of Graham ordinance for the heavy industrial use. I would like to make it known as evidence that the property was purchased by GFL in 1990. The construction predates the ordinance adoption of 1999, which reduced the front setback from 50 feet, which is the reason the building is cited as the way it is, to 100 feet in that area. In addition to that increase in front setback, you'll notice that the overhead power lines that run parallel with the western property line, you'll see 3 dashed lines on the left side of that map, just to the left of the white rectangle symbolizing the modular unit. You will notice that as the modular unit is moved to the south, the alley between the overhead power lines, easement, and adjacent building wall converge, such that the further you move the building away from the street, the tighter the lines get between the building and the overhead power line. We need to keep the modular building out of the power line easement and behind the front setback. Those two do not agree. So the lesser of the two is to ask for a reduction in the front setback. The resulting distance will be about 83 feet to the new structure, which is well beyond the existing 50 feet of the existing structure. To further add to the need to occupy this particular space on the property, the remainder of the use is lay down, trucking, sorting, and vehicle activity, which is not safe for the office folks to walk through during the daily activities. So at this point, I would like to read to you our findings of fact and then let you deliberate and make your decision. So if you will flip to page 4, you'll see this photograph. You'll immediately notice the electrical panels, the chain link fence, the existing GFL structure, and the proposed location, although it will be rotated 90 degrees, of the modular unit. We will reference all of those in the following findings. So if you flip the page to number 1, you will see item 1, unnecessary hardships would result from strict application of this ordinance. This is specific to the application of the 100-foot front setback. An unnecessary hardship to the property owner would result from strict application of this ordinance, as the location of any office expansion towards the yard area is not practical and increases in potential for foot traffic versus equipment traffic interference. Additional use of the yard area portion of the property by office uses separate from the existing office use area is not desirable due to these safety concerns where personnel are on foot in the yard area at the same time the machines are working. By utilizing this specific area of the property, further segregating the office uses from the yard uses can be promoted. Existing safety protocols can remain in place. Adequate service distance from outdoor electrical panels can be maintained. Separation of employee foot traffic versus employee machine traffic can be maintained, and additional potential for these site-specific interferences can be alleviated. Item 2, the hardships result from conditions that are particular to the property, such as the location, size, or topography of the property. The hardship results from conditions that are peculiar to the property. The construction of the waste industry's office and shop predates the application of the current City of Graham Development Ordinance. The presence of the transmission line and subsequent easement on this overhead power line create a convergence to the existing building line, creating an existing condition particular to the property. With increasing setback distance, the property line, overhead power easement, and existing building line converge to a width at which no use of the area in question can be made without creating a hardship or resulting in another dimensional or setback violation. The application of the 1999 City of Graham UDO over the existing conditions increased the front setback to 100 feet. This application of the setback was not a result from any action taken by the applicant, any known deed restriction, or development association conditions associated with the property. Furthermore, the petitioner has owned the property since 1990, predating the ordinance. Combining factors of the power line, change in front setback required, and the shape of the property, this condition is rare and unique to the subject site. Before I proceed with number 3, were there any questions? These hardships did not result from the actions taken by the petitioner. This is very specific in how the conditions of the property and not the modular are considered. The previously referenced conditions are specific to property boundaries, easements, and building placement preceding this ordinance, and were not the actions taken by the petitioner. The petitioner simply desires to make use of the property specific to this request to accommodate and increase a nonconformity or office use. When orienting the building in the least conflicting way causes a conflict with the UDO, a variance request can be made. The application of the Unified Development Ordinance dates subsequent to the construction of the existing building and the presence of the overhead power lines, and are not the result of the petitioner's action. An increase in nonconformity is, however, allowable by seeking a variance. Specific to the setback from Gilbert Street, the building proposed would be set back further than the existing building. Were it not for the additional constraints specific to the site, the building could be oriented in a way to avoid seeking this variance. However, the presence of the overhead power lines and their convergence with the existing building line create another site-specific limitation. When combined with the safety goal to separate machine operations from the office personnel, these factors give the applicant the need to seek the variance request. Do you have any questions regarding that section? Okay, number 4, the requested variance is consistent with the spirit, purpose, and intent of this ordinance, will secure public safety and welfare, and will preserve substantial justice. As previously stated in the section above, no decrease in existing setback distances are proposed. The requested variance is consistent with the intent of the ordinance to set back industrial uses from the front property line or right-of-ways. Specifically, the proposed building would be set back significantly farther from the right-of-way than the existing structure due to the geometry of the property and the departure of the Gilbert Street right-of-way to the north. The granting of this ordinance variance request will not adversely affect the public health, safety, and welfare. If granted, it will, however, improve the operational and safety conditions of the site. It will allow for the improvement of conditions for those employees and specific to their safety and welfare on the subject property. When you flip the page, you will see additional evidence. In the top left corner of this document, the year built for the existing structure was 1990. Subsequent to that is the existing footprint of the building according to the Alamance County tax records. Subsequent to that are deed references provided to you for chain of title indicating ownership prior to the application of the 1999 ordinance. Then if you'll flip several pages to this cover sheet, you'll see the City of Graham ordinance document. That is specifically included for your reference as you deliberate and also indicates the adoption date in 1999. I will add to our presentation a couple of final items. If I may, Chairman. Mr. Vanesh, if I may come up again one more time.
Why, certainly go right ahead, sir.
Leave the building where it is. If I may add, in addition to the concerns you may have about the location of a new building inside the setback, we have looked over the property and exhausted all of our ideas for placing it on other portions of the property. It simply is a condition of safety for the employees, and to locate it here adjacent to the office as opposed to out in the yard or where the machines are moving is better for the employees at GFL. And so that's the reason we're seeking the request for variance. At this time, I'll pause and await questions if you have any.
Nash, I have just one comment at this point. Under heading 3 and 4, they reference Gilbert Street. It's Gilbreth Street.
Gilbreth instead of Gilbert.
I would like to see that corrected for the official record.
Is that stated in the actual proposal of the variance? Did you see that in that?
Explanatory material.
Okay, curious.
But if it's evidentiary, it should be accurate.
Yes. Mr. Huffines, Mr. Wooten pointed out something needs to be corrected in your proposal, which is the street name as Gilbert instead of Gilbreth.
Yeah, I'm seeing Gilbreth, and am I missing something on one of the drawings? It's
Let me
misspelled.
point that out to him.
Explanatory material under headings 3 and 4.
Okay, thank you. We'll get that corrected.
It says specific to the setback from Gilbert Street,
Right, thank you. That's in section 3, and
And
then
4.
again in 4.
Yes.
again in number 4.
Okay, thank you. Mr. Chairman, we'll provide a revised copy of this for the minutes with those spellings corrected.
Thank you, sir.
Yes, sir.
Any other questions from the board for Mr. Huffines at this time?
Mr. Huffines, is there any particular reason why this structure could not be placed, looking at the map, which is not up there, the plot, looking at the cover page of the document you gave us? Is there any particular reason why it could not be located in the rear northern corner of the building? Outside of the For the conflict,
Gentlemen, sorry to interrupt, but moving forward, if you could make sure your mics are on and you're talking into them as well. So green light on the side of it, just go, Miss Jolly can go back in the minutes and accurately depict whatever's being stated. So.
Mr. Bias, will you repeat that, please?
looking at your
Cameron,
cover
would you put
page,
that on the screen?
Yeah.
looking at your cover page, I'm waiting for it to
The
come up
cover,
on
yeah.
screen.
Cameron, can you put that site back up on the screen?
Go expand out one more please. Worrying about it. Oh,
Where is that?
yeah. Okay.
That's right.
Let's see, that means going to camera. Can we go to this one?
Mr. Bias, may I approach and you just show me on the drawing?
Wait, everyone's gotta see. Looking at the building, there's the east side of the building. Got the number block, a northern block and a southern block. With the southern block being the larger of the two. If you put the building, the accessory unit at on the east side of that lower block towards the corner. Is there any reason why that wouldn't work? It would take it out of your,
So specifically there is a line, this one
Where
is
the cars
really
are
hard to
parked.
see.
where the cars are parked.
Where the cars are parked are for the drivers and that is outside the secured area. So there is a fence that runs basically at the common wall between the back office, back wall and the front wall of the shop area. Just above the number 2 in the I-2 designation, there is a fence that runs through there that separates the secured area where the vehicles and wastes are handled relative to where the office and vehicles and employees enter. So once you go through the side gate on the right-hand side of the office building, you enter into the shop and then enter into the activity area. So there, you would either put it in the parking lot where the drivers and office personnel park, or you would have to put it on the left side of the office building, adjacent to the power lines.
Can said fence be moved? And land reconfigured?
It is not necessarily easy because the tow motors moved between the building and the Connex and the Baylor storage areas to the left of the machine and shop area under the letter 2 or the number 2. So on the left side of the building, there's another secured area and electrical equipment that is attached to the building that runs the baler. It runs the material shed that is beneath the letter I in the I-2 designation. So all of those items would have to be disconnected and moved further into the secured area away from the office building per se.
Want to make sure we're talking about the same spot. I'm talking about right there. You have to talk so everyone can hear you.
So
Yes, please.
Cameron, Mr. Bias has pointed to a location
Which,
just to the south and east of the eastern wall of the mechanics building. So if you
Cameron,
could,
there are 2 blocks at the top of the plot of the plat for that property. A small block and a larger block.
Okay, so
Go
this
up.
area down here,
Nope. Go up with your pointer, go up with your pointer, go up, keep going up.
over here.
So you want to hover right there.
Oh, right here. So you want to, that's where you're proposing it.
Yes.
So you say southern, I think of all the way down the bottom, but okay, over here. No, that's fine. I follow. So this area right here, that's still abutting or adjoining or next to the building over here, I followed. So
Correct.
continue.
So that area is in the direct route of the skid steers and the machinery that work on the secured side of that fence. And I would want to separate the foot traffic from the machine traffic that's moving the waste, or trucks that are moving, or skid steers that are moving bales in that area.
It would appear that even if you put it in that spot, the modular building would still encroach on the 100-foot setback. If my feeble eyes are reading this correctly,
Mhm.
a 100-foot setback runs right through that, little parking lot there to the right.
Mhm.
So Cameron, you'd have to switch to a different.
Yes, sir.
One, maybe one that we provided that showed the entire site. And you'll be able to see, there, that's good. You'll be able to see the vehicles that Mr. Wooten, the line that Mr. Wooten is referencing runs right through the line of vehicles
It would
and
have-
the
it would just
corner
have
of
to-
the existing
You'd have to take that in.
mechanics building.
Mhm.
That puts the modular almost directly in the route of the vehicles that are operating as part of the waste hauling and baling operation.
Could those activities happen elsewhere? If you move the fence back?
I'll have to ask Eddie.
No, at this time, actually, we don't have room. Currently, we don't, we have to double park. So the trucks are parking in front of each other. So when we have a person who actually come in at midnight to rearrange for the drivers to leave safely. So currently, we don't have the room for that.
How many acres is this plot of land?
Sorry.
How many acres is this, how much acreage is involved in this piece of property?
It's
No,
2.69 acres. Up here on the top right here, it mentions property area, 2.69 acres. And I think that's just for the one section right here that's outlined. Because as a reminder, these are two separate lots here as well. So this is one, this is another.
The two separate lots, they're using them as one entity.
Yes, sir.
Just wondering.
Thank you.
So your preference for why not moving it to that corner is convenience.
Why I would keep it where we propose. It separates the vehicle traffic and the secured area from the foot traffic when employees, even customers are visiting the site without interfering into the activities where there are loaders, skid steers, balers, the waste trucks. We're trying to keep that separated. And the area that we proposed is the best and safest area for the folks that are employed by GFL.
Without reorganizing the site.
Can you say that again?
Without reorganizing the site.
That's correct. There would be significant changes to the site if we were to have to locate the modular elsewhere on the property or to retrofit the building in any way to accommodate the additional floor area that the folks need. I will say that we did work with staff, including the inspections, building inspections at length from about February until we made this request in April to try to conform in either connecting the buildings, moving the buildings in a different orientation. We were unsuccessful in working within the bounds or confines of the current ordinance. Once we discovered during our visit that the unit would be situated under the power lines, even if it conformed to the side and front setbacks, we still would not have an option. That's the reason we're asking for the variance. We were just at the end of our options.
Does there anyone else have any questions for Mr. Huffine?
Not at this time.
Any further questions, Mr. Bias?
No.
At this time?
Thank you.
Okay. Anyone else want to speak in support of this? Is there anyone that would like to speak that are opposed to this proposal? Since there's not two sides, and there's no cross-examination of any witnesses to take part of this hearing.
Do you have any questions for me or anything, Mr. Benesh, while the public hearing's still open?
I don't have any questions for you, Cameron, at this
sir.
time. We'd like to present both parties the opportunity to make any objection or corrections, but I don't think we have any to make other than to Gilbert Street.
Dinesh,
Yes,
at which point do we get to ask questions of the staff?
you can do that once we close the public hearing.
Mr. Chairman, if I may, I think as a point of procedure, we need to present you with our qualifications. Cameron is the City of Graham planner. He is an expert in application of the Unified Development Ordinance and the planning functions day to day in the City of Graham.
Mr. Cameron, would you be so kind as to present us with the qualifications that this Mr. Huffines is requesting
Indeed, for myself or him, so just so I, myself. So,
for yourself?
okay, as it currently stands, I am the planner one here for the City of Graham. I'm an apartment of my own with the assistance of the permitting tech up at the front. I've been operating as planner and understanding the development ordinance for the past 2 years now here with the City of Graham, and have done 2 years prior to this with other municipalities. And I based all of my decisions that have come from these draft finding of facts based off of non-biased black and white procedure that comes from the development ordinance. And based on that, those are my qualifications to present the evidence I've provided to you in the finding of facts and the finding of facts and conclusion of law.
Thank you.
Yes, sir.
Is there any member of the board like to ask Mr. Cameron a question about his qualifications or what he has presented?
You can move forward, Mr. Chad.
I'm sorry.
Go ahead. You're good.
And your qualifications?
As for myself, my name is Charles Huffine. I am a practicing civil engineering, geotechnical engineer, and environmental engineer in Burlington. Have been so for 32 years. So I would enter into the evidence of my experience. We're a registered professional engineer. Our office is located in Burlington. We do 100 of these types of projects each year. Over the past 25 years, it totals up to quite a few. So our functions daily would be to work with a property owner in any form of improvement to their land or in the provision for utilities, access to public roads, et cetera. In this particular case, it is the best way to site a structure on an existing piece of property, given its particular nuances. Our experience has been working in the state of North Carolina for projects from Asheville to Wilmington. I would also, at this time, introduce again Edmund, who has standing as the applicant. And if Edmund, if you would come up and just tell us why you have standing here. You are the applicant and the
Yes.
property owner.
Yes, I'm the property, I'm the general manager there. And if you would consider our application and look at the hardship we are facing currently with our employee and the growth. And it's really an eyesore. We have female and male still using a break room as a change room and one bathroom. So this will be a good addition to the city of Graham. And I think if you guys consider all our hardship, because if we have any other option, we will be taking that. I've been here 3 times and I live in Clements. So that's a long drive for me every night just to get this solved. We've worked with Cameron back and forth to find the right solution. I believe that we meet all the criteria for a variance, so at this time, we just leave everything in your hands and consider as,
And you are the general manager
and I am the general manager
at the Gilbert Street location.
at the Gilbreth Street. location. Thank you.
Thank you, Mr. Lawrence.
Thank
At this time, there's no further comments from the audience. I'm going to close the public hearing.
Need to be in the form of a motion.
Do we need a motion to do that?
Do you need a motion to do that?
No, no.
Yes, I
Yes or no?
Yeah, yes, sir.
I'd like to make a motion that we close the public comment section of the meeting. For this
Second.
variant.
There is a motion to close the public hearing. Do I hear a second?
I'll second.
All in favor?
Aye.
All opposed? Motion carried. So to summarize, we have a gentleman who is the owner of a particular property on Gilbert Street that has requested a variance due to what has been presented as hardships and a particular use of the property that requires a variance to be granted in order to safely move a building that is needed for his operation into a safe place. And based on evidence that was presented by Mr. Huffines that you have heard, along with other evidence that's in your packet as to hardships that may or may not have been created by the owner. So it will be up to us to decide whether to grant this variance or to say nay, basically. So I would like to have the board discuss this evidence and the arguments presented amongst themselves. Any questions that you may have for any other of the board members?
No questions, but comments?
Comments, questions,
Appropriate
whatever,
at this
yeah,
time?
yes. It,
I understand the need for this particular building. I think it's worthwhile, particularly
can
in our
you
business.
guys hear him?
Can you hear me okay? My. Close enough? Okay. I understand the need for this building. It seems to serve a legitimate purpose, business purpose. I understand what Mr. Huffines has said concerning the placement of the building. I think his arguments are legitimate. I have no problem with this. I think it's good as long as the building is rotated 90 degrees so that it fits what's seen here on the plat.
Based on what Mr. Huffines has presented.
Correct.
Can I note, while we're on the topic, I guess, of all this, but I think whenever we're making decisions, you all as a board, that they need to be made in the aspect of the conclusions of law. So you know how in the
Yes.
packet, we have the draft conclusion of law. If we're gonna go through all of those, that 1 through 4, and I guess whether or not you have the approval of like unnecessary hardship would result, and if you find that to be the unnecessary hardship is being met for 1, 2, 3, 4, then we kind of go from there. But I think that's where we need to be at, because eventually we need to be able to either approve or deny the conclusion of law that's associated with the variance request.
So
Okay,
you would prefer to have some verbiage more like,
Yes, sir.
I think he
So-
meets all the requirements and stipulations in the conclusions of law.
And I think it's
such.
more or less under the aspect of like why. So why is the conclusion of law in that aspect? So why, according to the board, is the unnecessary hardship resulting from the strict application of the ordinance? Things along those lines. So I think that's more or less the reason behind it.
So you basically are asking us to consider A, unnecessary hardship that results from the strict application of the ordinance and is not necessary to demonstrate that in the absence of the variance, no reasonable use could be made of the property.
So if you have an affirmative, I guess, decision upon that made amongst yourselves, that's what we're basically trying to figure out. And,
Mhm.
you know, the motion at the end would be to establish all the finding of facts and conclusions of law that were presented here. So you all would basically discuss amongst yourselves the four conclusions of law and why those meet or don't meet, and then they'll be brought to a vote of the conclusions of fact finding of law, and then go from there. Finding a conclusion of law.
Cameron,
Yes, sir.
the decision we make, I'm not sure who this is for, actually. The decision we make, is this precedent setting?
In regards to whether or not things like this would happen in the future, I believe it's certainly kind of up to you all as the Board of Adjustment as to what precedent you want to set. And if you do firmly believe that these conclusions of law do state that these applications were created by aspects of hardship, then I think that's basically the precedent that you all are setting is, you know, either you're firm in the beliefs that what all was provided is adequate or what was provided is not adequate. So that's about all.
I'm wondering something.
Yes, sir.
I have a workshop on my property that was put in before the code came in,
Mhm.
before code was invented for the town. Was for the town. In order for me to make an addition to it, I believe for residential properties, a 15-foot setback.
It depends. Is this an accessory structure that we're talking about? So it depends on where it's located, but majority of the accessory structures located in the city of Graham operate off of 5-foot rear and side yard setback. So that's basically kind of what that is. So if it's within those 5 feet parameters from your rear and side lot lines, then it's conforming to the current ordinance. However, I think I see what you're trying to get at, but if it falls within, like, say if it's in line with your corner and it doesn't have the 5-foot rear and side yard, then it's currently just a non-conforming structure. And if any change or alteration would be made to it, it just couldn't increase the non-conformity out there. So you couldn't, of course, build over your lot lines on either side, but if you're going further in, then that's a different discussion.
My lot goes around the neighbor.
Okay.
So if I wanted to expand it, it'd be hard to not be to stay within the,
It sounds like you'd be increasing the non-conformity, which wouldn't be allowed, and you thus have to apply for a variance to approve the reduction of setbacks.
what I'm thinking is like, this is what we're approving for me to be able to do that. Setting a precedent for that, that's all.
We must stick to
This case, okay.
this case, basically, not to sidetrack you, you're just trying to get an answer because that helps you with your decision making, and I can respect that. The one thing with the Board of Adjustments is you have to go basically by the law itself and not any personal feelings. You have to let each part of this 4-part explanation, so to speak, that applies in this case, such as in C, the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing the property with knowledge that the conditions exist that may justify granting the variance shall not be regarded as self-created hardship. So as Mr. Huffines pointed out, the setback was at 100 feet prior to 1997. It was in 1990 that he bought the property. And then the setback was changed after that. So the building would be okay to do what Mr. Huffines was suggesting if it was 100 foot, but since it's 50 foot, now it doesn't work. So it's going to be 30 some feet within.
I thought it was 83.
If I'm,
It's 83, but you,
87,
87.
87 feet
87.
to the corner, yeah.
if I may, just for clarification, the property was purchased in 1990. the initial highway setback was 50 feet.
Right.
When the ordinance was adopted in 99, additional industrial districts were created and a 100-foot setback was added, which then encumbered the existing building, creating the nonconformity.
So that's not a hardship that he created, is what,
That's
basically
correct.
what
He
that
didn't
is saying.
create that.
And if I may comment,
You didn't create the hardship, but we still, this is the rules that we get to work under now, the 100-foot, not the 50.
But he didn't create that hardship, but I mean, it was, the building was already there. The hardship was created after the fact because of the setback. That was,
correct. If this were still a 50-foot setback, then we would not be having this conversation.
Right.
And I would also like to state, in addition to what Cameron has provided in his guidance, considering variance cases are site-specific, case-specific, and they are geared towards finding these facts of law in an effort to not necessarily avoid setting a precedent, but to individually focus on individual projects on their individual merit.
and in the B, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Mr. Huffines touched on that. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. With those three, it's up to you and the rest of the board and myself to decide, along with the last, the requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice is achieved. Mr. Huffines also touched on safety in his findings and presentation. Mr. Huffines, you have something else you want to say?
I would just add to that one topic we did not discuss presented from Cameron or myself, but I think I'll speak and then let Cameron have a chance to agree or disagree. In the spirit of the ordinance, the setback from the road in an industrial district is designed to provide separation from the traveling public. In this case, the building's already 50 feet from the right of way. The only use specific to the traveling public would be foot traffic into the building from the parking area where there are already cars parked. And this building would be located further away from the road right of way than any other portion of the existing building. So the spirit of the ordinance is designed to keep the separation from the right of way to the area of operations. And we have tried to conform to the spirit of that and to the best extent possible. As such, the distance we've moved the building from the right of way is as far back as practical as we can get.
Does say here, though, that if the draft findings of fact that were presented by staff or the board specifically state whether any shall be revised or specific wording of revisions. If you see anything there that is incorrect or needs to be changed.
So, Mr. Benes, that's kind of what I was getting at earlier is eventually we have to approve the conclusion of law based on what you all see to be fit for each one of the unnecessary hardship descriptions.
Exactly.
So that is what I provided and what Mr. Huffine also provided, being our finding of facts and conclusion of law based on our expert analysis of it. And now it's time for you all to take what Mr. Huffine and I both presented you and make your own educated and I guess based on what was provided and document your conclusions to number 4 or number 1 through 4, but labeled on the resolution is 4 through 7. So that's what the discussion aspect between all you all is needing to be right now, is setting that precedent of what you all find to be the conclusion of law based on everything that has been presented to you as such. And I think that everything has pretty much been presented at this point.
Can I ask a question?
Yes, go ahead.
I would like, the staff has made a recommendation to deny.
Yes, sir.
I would like to have clarification of thought process behind that.
Yes, sir.
Please.
So, Mr. Huffine hinted on, the spirit of the law in regards to understanding, having that building being further back 87 from the 50-yard that's already out there. So it's a reduction, but the letter of the law that I look at, that is what's black and white through all of these requirements being, the hardship, strict application of the ordinance. It's 13 feet away from the required setback that's inside the development ordinance. So that's what my aspect is, it's letter of the law, looking at all of these from the development ordinance standpoint. And presenting that to you all, that is my finding, is that all of these areas, they're impeding on the front yard setback. There's areas surrounding it that, area where it could be placed, and that's based upon what I have. And they also presented the aspect of their exhibit for power line aspects. I had nothing tied in to do with the development ordinance on my end, but expert, I guess, analysis from their part. So that's from you all to take whether, their aspect of that or the letter of the law piece of it kind of falls into your aspects of the, conclusions of your law piece. So that's where all of mine came from, was just basically going off what was written in the ordinance and basically seeing that it impeded on it. There's extra places, there's area on the lot where it can be placed, but now, with the discussion of, traffic area ways, things like that you all have heard, expert analysis that has been provided. So that is completely up to you all, and I won't speak any further on any of it, so.
The general consensus is
And as a reminder as well, is these conclusions of the law is all four of them have to be met in order to get
Mhm.
approval as well.
You're right.
So if we can't hash out all four of you agreeing on all four of the conclusions of law for approval, then it's ultimately denial. So,
denied, right?
yes, sir.
Well, I need to hear from you as a board, individually, as to how you feel. If you have any questions in that regard. Unnecessary hardship would result from strict applications of the ordinance. It shall not be necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. Everybody understand that? The hardship results from the condition that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. Everybody understand that? The hardship did not result from the actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. Understand that? We have to take a vote, and it has to stay with those three plus the requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice is achieved. We have to come to a point where we have to make a decision based on the law, how it is stated. Any comments before we take a vote?
So again, I think that the best process moving forward, as you saw in the draft decision that was provided by staff, is there's description of why or why not you approved with the section of hardship. And I think that is more or less, you understand the aspects of what are the requirements of the variance being these hardships. But as I mentioned, you have to take now what Mr. Huffine and I have both discussed and establish it to these 4 criteria, and then move to approve or make a motion to approve based on what has been provided in the conclusion of law. So I think taking it one by one and figuring out, what reasons why it conforms to the hardship or does not conform to the hardship, and then go to the next one and the next one, next until you got all 4, and we have a written description out. And that way you can approve it based on the draft or the provided that has been provided by the board. So.
So how would you like me to proceed, sir?
Well, as I mentioned, you all kind of have to come up with a conclusion of law based on what has been provided below. The application or if the unnecessary hardship would result, if it wouldn't result, why is that?
Okay.
And kind of go from there. So
The
whenever you all-
application for the variance in the case BR 2301 is properly before the Board of Adjustment, who has jurisdiction to hear and determine this application. So we have to determine by what reasons that we would grant this variance.
So I'd start on, it's just the 4 hardship pieces of it. Those first 3 are basically the conclusions of law that we met tonight.
Right.
And those are, if you want to go through those, you definitely can as well. But I think the more honing in is on the hardship piece of it and figuring out whether or not y'all, if you want to come to the consensus and agree that all the hardships aren't, or they're not hardships, or however you want to do it. But I think the best practice is kind of go with how it's been presented here as well, and provide, based on the expert analysis that have been provided by the both of us, whether or not what you've heard, you can take that and apply it to whether the hardship is resulting or is not resulting from the.
Is a hardship, in the board's opinion, that was presented.
Do we need to take
Meet
each
the standards
individual,
of variance?
do we need to take each individual item?
Well,
address
as Cameron has suggested, the main thing that we need to move on is whether the hardships are there significant enough to grant the variance. Mr. Huffine.
Chairman Benesh, it may be helpful if you'll turn to page 33 in the document that I provided to you. The cover of which has this drawing on it.
Which one?
So it's the document I handed up,
Uh-huh.
has this on it. If you'll turn to page 33,
33.
it'll say 33 at the bottom of the page.
14, 33,
Uh,
35. Okay.
that's at the-
All right.
I don't know.
If you'll notice it and this is directly from the City of Graham Development Ordinance as a
Mhm.
guidance for what the process will be. Item 2 variances.
Mhm.
There are 4 items, A, B, C, and D. And it is very typical that once we have heard the evidence from all the parties testifying, that the board would then formulate a consensus or a statement based on the evidence that they have heard, what their opinion would be, and then move to the next item. The evidence has been presented to you by the property owner withstanding as he is the general manager there. The evidence has been provided to you by Cameron, who is a town planner based on his knowledge and strict application of the development ordinance. The evidence that is presented from our firm is based on both of those items in addition to the outlying utility conflict, which Cameron has said he was not aware of. We will also say that through each one of these 4 items, the presentation earlier in this document gives you the wording to include in the finding for each specific item. So just as Cameron has provided you with his draft findings, which you may change as you deliberate, as have we. So you can combine those 2 items and then formulate your opinion for each of the 4 subcategories under item 2.
Chair, may I take a bit of a stab at this? See,
Go right ahead.
okay. And you guys,
What I was gonna suggest is, so deliberate amongst yourselves.
Right.
Try to figure out which way you want to go. And somebody make a motion incorporating the findings of fact and conclusions of law and vote on that motion.
well, that's where
Okay.
I'm trying to head that direction and see if we can get it right for the record.
We've been trying to stab at that.
Yeah.
Is it around?
We're dancing all around it and I'm
Go ahead, Mr. Wood.
okay. Number 4, unnecessary hardship would result from the strict application of the ordinance. It shall not be necessary to demonstrate in the absence of the various, no reasonable use can be made of the property. I think the evidence that Mr. Huffine has presented is sufficient for this one. I think that we have seen that it would be unfeasible to locate the structure anywhere else on the property and still be within safety and the use guidelines. Does that seem like a proper response or?
I mean, if you want to take each one of them, or if you just want to do it all at one time, if one of you wants to make a motion.
Because I understood what Mr. Huffine just said, read from, it was.
Yeah, I think you can do it. You can go through either one, but I think what most of the time.
It's a
you're used
consensus
to
of all.
having
one time.
one motion and, incorporating all of them, like saying my findings of fact are this and my conclusions of law based on this, or you start out, I make a motion that we affirm or that we deny and you tell why, and then.
So if
got
you
that
want to
motion out there on
consolidate
the
all
table.
4 of them into one, the verbiage would be something, if you wanted to consolidate all 4 of those into one, the verbiage would be something like, I find that the presentation of the requester is sufficient to meet all of these hardship stipulations.
Maybe get it, the hardship because of so-and-so or a certain reason that it didn't meet the hardship and then that
Okay,
another standard because of this and, you make your motion and I want to have this either approved or denied because it meets this because of that, it meets this standard because of that. And you got the motion out there, then
okay, all I'm trying to do at this point is to get something out on the
Yes.
table so we can discuss it. So let me just pop through each real quick.
okay.
And I'll try to be quick about the whole thing. Number 5, the hardship results from conditions that are peculiar to the property, so forth. I think that is, the presentation by the requester was sufficient for that. In that, especially in light of the fact that it was purchased before the development ordinance came in with 100-foot setback. At the time, it was 50. And so they're dealing with a peculiar and unique situation in that regard. Number 6, the hardship did not result from actions taken by the property owner. I think, again, the presentation was sufficient. It was not a self-created hardship. It was a matter of circumstance, matter of happenstance, that, again, the structure was erected prior to any planning or inspection review. Didn't know about it, but he was going on the best information he had at the time. Number 7, requested variance consistent with the spirit. Yeah, I think, again, the presentation was sufficient in that it would permit the structure within the desired front setback, especially if it was rotated to 90 degrees. That kind of get the ball rolling.
Yeah, if you want to make that in a motion form.
I'm not making a motion at this time. I'm just getting comment out so we can deliberate.
That's basically what I was trying to get at, is just get all 4 of them in the form of responses to each 4 of them, and then we'll go from there. So,
Right, is that
perfect.
where we're,
Yes.
okay. I'll shut up and let you guys have at it as well.
Something just crossed my mind.
Mhm.
Am I supposed to be an alternate?
No, no, sir. So basically, at this point, it's figuring out whether you agree with what Mr. Wooten provided or not, or if you disagree. Or if you agree, then you can move it forward with a motion based on that, the evidence that was presented by both parties, a claim to that the hardships are being met for all four categories. And like I said, it's kind of based on you all and what was provided by the applicant and the presenter and staff here, so.
Something to the effect, motion to grant or deny based on the evidence presented to the hardships that were not created by the applicant and that the conditions are peculiar to the property and the variances shall be consistent for public safety.
Are you throwing a motion out there right now or?
No, I'm just compiling it
Mhm.
together as a statement to make a motion. If
Yes, sir.
Someone can kind of put all of that in context. You see what we're after?
Again, Mr. Chair, all I was doing was just trying to get.
No,
something
no,
out
no,
there
we
to-
need a
to
motion.
discuss.
To grant or deny based on the evidence.
Right, I understand that, but there needs to be discussion about it.
Yes.
Okay.
So
All I was trying to do is just get us started.
do you
prime the
have,
pump.
do you have some comments on that, Mr. Box?
Wooten has brought up several very good points. I am still falling behind with standing with the staff's assessment of item number 4.
And what part of item number 4, the requested variance is consistent with spirit, purpose?
That there are other items on spaces on this property that this building could be.
Other places that the building could be put,
Yes.
moved to.
Right.
Any comment? Discussion?
I think based on the expert testimony from Mr. Huffman and Mr. Larson and Cameron there, I'm in agreement with 1 through. Fire.
Vice bringing up a legitimate point, but then too, the evidence presented would be indicative that to put it on another place, another position on the property would be disruptive to their business practices, cause them hardship,
And a safety
safety.
issue because the way
A
the
public
parking lot is set up,
Not public safety.
Well,
not employee
not
safety,
public.
not from the employees.
Well, I believe Mr. Huffines did touch on public safety from the standpoint of visitors. They're coming to that property that don't work for the company.
The parking.
Still feel challenged by that thought process.
But we have to, put together statement from us in the form of a motion. If you like to make a motion You like to make a motion, Mr. Wooten?
I would be glad to. See if we need to get the wording down. I'd like to make a motion that in light of the evidence presented this evening, it does meet the 4 criteria of the hardships and grant that the variance be, or requested the move that the variance be granted.
I agree with Mr. Wooten.
Well, we're at a point, that we have,
I believe Mr.
Did-
Wooten made the
did he-
motion.
Did you make a motion?
did you make? a
Yes.
motion? Oh, I'm sorry. Sorry.
And I was just about to turn to you and say, is that sufficient to cover all the aspects or?
Mhm.
Pardon?
I couldn't really hear. I think you got to hit on all of them and say why.
Mhm.
In the motion, we do need to address each of the issues. Each of the 4 items.
Give it a whirl.
Go for it.
I'd like to make a motion to acknowledge that this application for variance meets the requirements for point number 4, unnecessary hardship. That it also meets the requirements and meets the needs for hardships of the resulting from the conditions of the property. That the condition request does not acknowledge that the applicant is not, that the hardship is affecting the applicant irregardless of the applicant's actions. So it's the site, not the applicant, that's causing the issue. And that the applicant, this is application for variance, is consistent with the spirit and purpose of the law. Does that work? Thank you.
Scholar is born.
All 4, that was a motion to approve.
Second, you gotta have a second.
I know, I said that I have a motion
Oh, okay.
to approve. Do I hear a second?
Second.
All in favor?
Uh,
Do I need to poll?
I'd poll, yes, sir.
I didn't say aye.
I'm sorry,
I proposed it. That didn't mean I.
You asked for, all in favor, say aye, but you didn't ask for any opposal, so, or opposition.
any opposed? Aye. Okay, so I will poll. Mr. Wooten,
aye.
Mr. Bailey,
Aye.
Mr. Byers,
Nay.
and myself, Mr. Benesh, aye. This is 3-1. The motion fails.
Mr. Chairman,
Yes,
would you give us an understanding of the procedure now? Does this go nonetheless to the city council? Does this end it entirely? What is the status procedure?
it is my understanding it does not go to city council. It is decided here. Is that correct, Cameron?
So as it stands, the Board of Adjustment does not have any appeals outside of their decision unless it's the Supreme Court, I think it is, so.
Dinesh, I just wasn't clear. Has the city council ever taken action to establish that as the authority of the Board of Justice? Has the city council ever taken action to establish that as the procedure? I know it was discussed at one time. I don't recall it ever having been adopted.
I believe that's what's inside the development ordinance, as the Board of Adjustment is the entity that hears all variance requests. And I think what you're referring to is the special use permits, where they were thinking about letting the Board of Adjustment hear the special use permits. And that's what it was, but the variants are a completely different aspect of it.
Thank you.
Well, as the decision was to deny the variance, we move to public comment on non-agenda items. Are there any items not on this agenda that anyone would like to discuss? If none, do I hear a motion to adjourn?
So move.
I make a motion that we adjourn.
All in favor, say aye.
Aye.
All opposed? Motion. Adjourn.
Didn't know how it went. Didn't go how I thought it would.
That was a tough one.
You're welcome.
I don't either.
Nice.
Acting chair.
Yeah, Chair will get to come back. Yeah.
Since that was a little long, we're going to take a break just before the planning zoning meeting opens for 5 minutes. If you want to stretch your leg or go to the bathroom or something, we've got to wait on one of the board members to come back in. Thank you so much for your patience out there. It's been a long time since we've done a Board of Adjustments meeting and a lot of new members. And so thank you for bearing with us on that.
Thank you. Ron, so are you sure they have to give a reason? Yeah, I think that. I don't see that in any requirements. And you can state it the way you first said it. I don't understand why you were insisting on them giving reasons for, and. Just.
we certainly encourage you to go to the city council. In any agenda item, we are a board of what we call an advisory board to the city council. So if you have a favorable or disfavorable outcome, please go to city council. They have the final say. So at this time, I'd like to call the meeting to order.
Mr. Benesh, since kind of operating as we were before as well, without,
Yes.
with the absence of the chair and the vice chair, if you could just advertise it in the form of a motion to open it. So
Yes, I need a motion due to the absence of a chairman that we make a motion to appoint a chair for the meeting.
I was more or less advertising as a motion to open the meeting, as we did with the Board of Adjustment as well, because we still don't have an acting chair or vice chair.
We have to have a motion to open the meeting.
Yes, sir, as we did with the
Okay.
Board of Adjustment as well.
Okay, all right.
I'd like to move, we open the meeting.
I have a motion to open the meeting of the Planning and Zoning Board. Do I hear a second?
I'll second.
All in favor, say aye.
Aye.
All opposed? Motion carries. Now we need to appoint a chairman. I hear a motion to appoint a chairman,
Appoint a temporary chairman, just.
temporary chairman.
Motion
For
to
tonight's
appoint
meeting.
Temporary Chairman, Mr. Mike Benesh tonight for the night's meeting.
There's a motion to appoint Mike Benesh to chair the Plan and Zoning meeting. Do I hear a second?
I'll second.
All in favor?
Aye.
Aye.
All opposed? Mike Benesh is chairman, Plan and Zoning. Okay, thank you, sir. I will now call the Planning Zoning Board meeting to order at 8:20 PM. Roll call and confirmation is Tony Bailey.
Here.
Chad Huffine here. Dean Ward. Absent. Jerome Bias,
Present.
John Wooten.
Here.
James Stockard,
Present.
and myself, Mike Benesh. Pledge allegiance, moment of silence, ask people to rise and
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'd like a motion to approve the minutes from the May 16, 2023 meeting and planning board. Are there any corrections need to be made? Do I hear a motion?
I move that we accept and approve the meetings as written and presented.
I have a motion. Do I hear a second?
I'll second.
Mr. Chair, may I be recused since I was not on the board at the time?
Yes, sir. Accuse Mr. James Stockard. He was not a member of the board at the time of the last meeting from the vote. All in favor? Say aye. All
Aye.
opposed? Motion carries. Cameron, can you read the report to introduce a conditional or zoning request?
Yes, sir, indeed. As you have in your staff report, this is a request by Leah Terra Graham LLC and agents thereof to amend the existing conditional rezoning that was approved back in 2020 to make changes to the site-specific plan to remove street tie-ins to Tonewood Drive, reconfigure open space and reduce the number of mail kiosks. Provided to you all is the original approved plan along with the conditions associated with the approval. The previous conditions were that the Windy Drive would not be connected to the existing street sub out, but the easements would be given to the city for water, sewer, and other utilities as necessary. Phase one of this project has been complete from the technical review committee but has not been fully platted out, but we have recorded a plat for this area here. So they are currently constructing the homes in phase one. But this came from reviewing the phase 2 and 3 plans from the Leoterra folks, where they are requesting to remove that Tonewood Drive street connection and removing some open space and reconfiguring some lots. So that is about all I have. As I mentioned, the pre and post plans are there attached on your thing, and I can pull them up on here as well if you have any questions.
Thank you, Cameron.
Yes, sir.
At this time, I'd like to open public hearing up. Anyone that wants to speak to this proposal?
Mr. Nash,
Please.
do you mind doing that in the form of a motion as well?
Okay. Let's see, pardon me. I'll call for a motion and a second to open the public hearing. Do I hear a motion?
Make a motion, we open public hearing.
Second by anyone?
I'll second.
All in favor?
Aye.
All opposed? At this time, I'd like to open public hearing. Anyone would like to speak on behalf of this proposal? Please come forward, state your name and address.
Hi, my name is Kat Lyons with Leoterra Development. We're the owner of the property. We're developing Lacey Farms. Just kind of expounding upon what Cameron was explaining. Phase one has already been platted out and is currently, there's currently vertical construction going on. During the design process of phase 2 and 3, there were just some minor tweaks we wanted to make to the site plan that we think are fairly minor. One is the connection on Tonewood Drive. In terms of construction, it's a little bit unfeasible and pretty disruptive to the neighbors. And so we wanted to avoid that. It is a tight space in between those neighboring properties. So we wanted to eliminate that connection. Wanted to drop a mail kiosk location. The USPS recently has said that they prefer one centralized location in the neighborhood. So we're eliminating one and just keeping one central. And then we reconfigured some open space in order to gain a couple of lots, but it still keeps us under the initial approved lot count for the site when the site was initially approved back in 2021. So we think, again, they're pretty minor. They're consistent with the the conditions that were approved with the initial site plan. One of those conditions was relating to Wendy Drive. We are still not connecting to Wendy Drive. And if there's any maybe more like technical specific questions, the design engineer Vince Townsend is also here with Green Mountain Engineering. Any questions or anything you want to add, Vince?
Any questions?
Questions, Mr. Chair?
Where did you say you lived at?
Oh, I personally live, does that need to be my personal address or Leoterra Development?
I think you can give Leoterra's. So
Okay, 110 Shields Park Drive, Suite A, Kernersville, North Carolina, 27284.
And your name again, please?
Kat Lyons.
Okay, thank you. Cameron, can you pull up the revised
yes, sir.
plot, please?
So presented on the screen in front of you all is the revised area. As you know, they do have the kind of areas bubbled out as where they are making their requested changes at. Number 3, I guess we'll start here at the front of the property since phase 1's already kind of under construction over here. This is where their approved mail kiosk location was for the phase 1. This other 3 back here is where the secondary kiosk located was at. So they're moving the kiosk from back here that was approved to all a centralized location up here at the front.
There was another kiosk down there, yes.
Yes,
that
sir.
You got your hand on. Yeah. So going from 3 down to 1.
Yes, sir.
And that
All
was a
there.
USPS request?
Yeah, recently USPS, we've seen this in all of our sites and all the municipalities, they have started preferring one centralized location. And so a lot of and this has like been pretty recent. And so site plans that were approved like even a couple years ago, we're kind of going back and confirming that they want the centralized location. And the answer has been yes. So all kiosks will go there.
Does that kiosk, the centralized kiosk, does it have parking?
It does.
Okay.
Seemed like there were 6 plus 2 handicapped. Is that correct?
Do you know exactly how many? Yeah, I'm not sure the exact number. It would be noted somewhere on the site plan.
I think it was a requirement of the construction drawings for phase one that they incorporated parking. I don't know the exact number, however, so.
But you believe it is 6 plus 5 plus 1 handicap,
Okay.
total of 6.
Yes, sir. And over here, I guess we'll go from 3 to 2, as you can see, as Kat described, and I did this Tonewood Drive connection over here into Darrell. Originally, it was supposed to, I guess, run all the way through Darrell Drive. This parcel right here, this parcel right here, are currently, I guess, beside the potential construction that's moving. All this area right here is currently grass, and it was just, I guess, dedicated as an easement for future connection when this subdivision was approved. And as she mentioned, disturbance between neighbors for constructing the connection over here is one of the reasons as to why they're not, requesting, or they are requesting to get the removal of this area. And then back over to the one over here is where original open space was at. But now it's being incorporated with this top corner of lot 128 and 117 and 125.
They go before TRC.
Yes, sir. So phase one has already been TRC approved. Phase 2 and 3, TRC has looked at, and pretty much I think it's minor engineering comments, and I couldn't give really many comments until we got updated approval on the conditional rezone plan, because I'd base mine off of whether or not they get city council approval on the new one, or if they want to stick to the old.
I was asking about TRC approval on the stub out or closing off, is it Winsome?
Tonewood right here.
Homewood, yeah.
Yes, sir.
Tonewood,
So
yeah.
I believe technical review committee looked at it, and I think we're really impartial as to whether or not they do it or not. I think they definitely provide understanding as to why they don't want to do that. And honestly, they have connections going over through this development already over here that's going to eventually connect over into this area as well. So, I mean, we're eliminating one and still having another one. So.
Is that going to make any, did you do any kind of a traffic study to see what kind of an impact that would have, the reconfiguration? Of the
No,
Wendy and Tonewood, traffic flows, traffic patterns?
so Wendy, nothing is changing with Wendy Drive.
Right.
Which
But
is
on,
up here, yes, sir.
but on, I'm sorry, on Tonewood there is, as Cameron was saying, we're, number one, we're meeting the number of entrances that we need for the subdivision. And we do have, so we have multiple points of entrances, and there are already existing stub outs. So there wasn't necessarily a need for like an adjusted TIA for that. That was never brought up or asked.
So you
of us.
don't anticipate any kind of a change in the traffic?
We do
patterns?
not,
Okay.
no.
Any more questions for Ms. Lyons? Time? Thank you, Ms. Lyons.
Mr. Chairman,
Yes.
is the street that remains stubbed out, or rather connected
Which one are you referring to?
to the left? Okay,
Over here or this one?
no, it's that one.
Archer Drive. So Archer runs through this middle area right here. So it's a connection right here into I believe this is Council Creek subdivision that's also getting developed out, and a vacant or a piece of property over here, farmland,
All right, and then the first one you pointed to, does that connect also? No, it doesn't show it on this.
to the Council Creek development.
Yes.
Yes, sir. So you can kind of see down through here that there have been plans for the Council Creek area to kind of, I think this street back here is stubbed out as well. I think we can
But my-
probably,
Question is the other street that you first pointed to. If you can go back
yes, sir, sorry.
to the left. To the left of that,
Oh, this one over here.
does that go into another street in the adjacent development?
Yes, sir. So that one will be going into that Council Creek development as well.
So the first two will, and eliminating the back.
Yes, sir.
Any other questions from Ms. Lyons this time? Okay, Ms. Lyons, do you have anybody that you would like to speak on behalf of this?
Yeah, the engineer of record, Vince Townsend with Green Mountain Engineering.
Please state your name and address.
Vince Townsend, 1A Wendy Court, Greensboro, 27409. I did a lot of the work on these plans and I just want to point out that where Archer Drive ties in, that's an existing road that had been there for quite a long time. And the next road to the west, Keystone recently completed it, and when we finish our phase, it'll be tied in as well. I think that's correct. I think it's Green. I can't remember the name of it. Actually, I may be,
You see on the original plan?
yeah, I think I may be incorrect, actually. The one we're tying into, Archer is the one that Keystone just completed, and Cameron was right. I had my streets mixed up. And they have not yet completed the next one to the west, which is Hampton. But by the time we're finished, all those streets should be connected. So you have 4 different access points into this subdivision and out of it. I just wanted to clarify that.
And your last name was
Townsend,
Townsend. Any questions from the board from Mr. Townsend?
I do just a few. Mr. Townsend, just north of the phase 2 label, there's a street that's stubbed to the north. Is that one gonna remain?
phase 2.
Right there where, yeah, Windy
Oh,
Drive.
That's Wendy Court. And that was a condition of the original rezoning that street not be constructed. The neighbors in that subdivision didn't want the traffic going through their neighborhood. But the planning department wanted us to dedicate the right of way so that in the event you all change your mind someday, you could tie the street in. So to answer your question, there's no vehicular access through that Wendy Court.
But it's dedicated public right of way.
Yes.
Do the utilities connect through to the adjacent cul-de-sac?
We did not connect the water, but we do have a storm run running up there to, pick up some storm drainage and run it over to the pond.
All right, thank you. And then the triangle item number 2 down between lots 155 and
yes.
156.
Um,
So that is the road in question that would,
Oh, yes. Yeah, that's Tonewood. We were going to tie in there, but the grades made it very difficult. And we had 2-to-1 slopes to stay within the right of way adjacent to 2 existing homes and conversations with your engineer who was reviewing our plans, he gave us an option of, eliminating the connection or, trying to figure out a way to build it, but there really wasn't a good way to do it without really upsetting the neighbors. So that's why we're here really, is to get rid of that connection.
Mr. Huffine, you can also see this is the original approved plan that shows the connection going right here. And the intention was for the development to continue on through as well to Darrell Drive.
is there a need to have utilities to connect through that?
We have adequate water supply without any connection, and the sewer runs out down the stream in the north part of the property over to Ridge. Can't remember the name of the road back there, but so really no need to connect it. Our water supply is adequate without it.
So is it the intention to take number 2, the triangle number 2 and create an additional lot and
No,
You-
I mean, we thought about it, but we didn't want to appear greedy, so
No.
we left it as open space.
all right, and this question will be for Cameron, the right of way to the south of the triangle number 2, is that current dedicated public right of way?
Yes, sir. I believe so.
Yeah, that was one thing the engineer mentioned, is that you may want to petition to abandon that right of way, and half of it would go to each of the adjacent landowners.
Yes, sir.
Which
I have nothing further.
Which spot are we talking about at this point?
This area, the bottom half of Tonewood Drive. So what Mr. Townsend was referring to was basically city council petitioning to abandon this right of way and give half of the property to this property owner and the other half to this property owner.
Yeah, I think they'd probably prefer that over having a road, 10 feet below their house, right next to it.
I have nothing further. Thank you.
Okay, thanks.
Any other questions from the board, Ms. Townsend?
Thank you.
Is there anyone else that would like to speak to this proposal?
Chairman and Board. I'm Janice Holt Cashin. I live on 1820 Lacey Holt Road, Graham. If you look at the map, I live on the corner of Lacey Holt and Monroe Holt Road. It's a farm. Will you bring up the map showing?
Oh, yes, ma'am. Sorry, I just had it up. I
Mr.
was
West,
circling around
thank
this area
Okay.
right here.
So, I live in the R18, 3 acres in the corner of Lacey Holt, Monroe Holt. The farm is all connected, 25.94 acres. And that is a farm and it doesn't, it's always said R18, but it does, and it's exempt from your zoning, ETJ. Okay, my concern is at the first meeting in 2020, my real concern was that this is a farm. We farm it still. It has been farmed since the early 1800s by Henry Monroe Holt, my great-grandfather, David Dewey Holt, my grandfather, and my father, David Lee Holt, and now it belongs to me, what little was left, the twin. Okay, so the concern was the buffer area. And it's a 30-foot buffer area that was approved. Okay, so my point of concern is the 1,166.77 feet property line where there's supposed to be a 30-foot evergreen buffer. And on this plan, which I was never notified when plans differences were made for section 1, for phase 1. As a landowner, I was never notified that anything was being changed from the original approved plan. So when I got my letter about 8-9 days ago saying there was adjustments, and when I saw how they had built it, I knew that things had been changed. But anyway, my concern is Archer Drive at the end next to my property line. They, at the first meeting, had said they needed to put some kind of fire because for fire code, there needed to be a turnaround because you got 193 houses originally approved. And, the way it is, there's fire issues. There's it's conditional rezoning, but this is pretty much R9 zoning and following R9 zoning rules with some exemptions, right? So, if you notice at the end, I don't know if you can, originally, in the original plan, it was just stubbed out like the other road, just straight out with the buffer zone. Now they put in, I reckon that's a turnaround. I assume that's what that is, Mr. West.
Yes, ma'am.
Okay, so, and it's over in the buffer. So my request, so that's my problem, is for you not to approve the design of this part of the Archer Drive at the end and to redesign it so it will not be in the 30-foot buffer. You have safety issues going here, which I brought out in the 2020 council. We farm up to that boundary line. It is heavy equipment. There's spraying going on, there's planting on, and you've got houses and you've got people coming right up to my boundary line when they break through the 30-foot barrier. So this was my real concern here. So I just wanted to restate, this is farmland. The R18 is on my 3 acres. And that is what, that turnaround is a problem. It's too close and it's infringing on the 30-foot evergreen buffer. Can you see what I'm talking about, gentlemen? So that's my request for that part. The other part is I was just wondering when, okay, so where all these streets are stubbed out into my property, I'm not planning on selling. So that can't be considered an exit for this development. So my question is, how many exits? They have 2 on Lacey Holt presently is all they have. And the traffic is horrendous. It's going to get worse with all this development. I didn't understand why you would really want to close down the Tonewood. Because you'd already closed down the Windy that would alleviate all the traffic that's being directed off Hill Road. I don't have any problems with the kiosks being moved. I mean, because that was, post office asked him for that. But gentlemen, if you would please not approve this design there. If you've noticed, it's right, that, especially that one corner is right on my property line. My shop and my shed is not too far from that corner. In fact, it comes out right there at Eric Drive. It's kind of where there was also an additional stub in at one time, but but not to this part, but on the other side towards Carrollton. But anyway, that's my request. To be considered.
Are there any questions from the board? This time?
I'm just trying to hang on to the farm and keep everybody safe.
I missed your last name. I heard you were in the Hope
Janice
family, but
Cashion.
thank you, Miss Cash.
Okay.
Does anyone else have any comment?
My name is Lindsay McKinney, and my husband, Mark McKinney and I live at 632 Wendy Drive. That is the little cul-de-sac. Sorry, I didn't come prepared tonight. I didn't know you're going to be doing the public, allowing us to speak, so I didn't come prepared. But yes, that's our property right there. Yeah. I knew that we had the 30-foot buffer. So I was outside one day watching the logging trucks. The girls and I were fascinated about it. I have 2 daughters. And the logging truck came down and started cutting down the buffer. So I ran out there and said, wait, there's supposed to be trees here. And he said, well, I got here early this morning and my instructions were just to remove every tree in this field. So I said, go back and check with your boss and make sure that you're not supposed to be taking down this 30-foot buffer. So he, for the rest of the day, went out and continued the other side, the southern side of the property. Fast forward a bit, I've talked to quite a few people from different agencies, planning boards, Leoterra. And the impression that I'm getting is that those trees were cut down by mistake. There's about half of our property line that the trees are thinning out too much, and about a third of our property line, they've taken down all the trees. And since then, we've had flooding on our property. We have a drainage ditch that goes beside the property. That's been flooding. And that ditch is kind of a catch basin for flooding that occasionally happens underneath our house in the crawl space. So, and I do have pictures of that. If you guys wanted to see the catch basin filling up, and I'm a little concerned that underneath our house will start to flood. And also with that buffer being gone, we live on that piece of property. We are getting continual dust, and I'm chewing on dust right now. I feel like there's dirt in my throat. My eyes are constantly bothered by the dirt. So I don't know if this is something that you guys can do. I've been talking with Miss Lyons back there, and she's cooperative. But every person I talk to says, I'm not the person you talk to. You'd have to talk to so and so, and then I get a hold of that person. I'm not the decision maker. You have to talk to that person. But my request is, if I know that those actually right now, okay, on Friday or yesterday, a guy came over and working with Leoterra, and he said that what the plan is right now, they're going to cut down 10 feet of the 20-foot buffer and leave 20 feet untouched, because that 10 feet on the inside of their property line, they need to use that to do some drainage and catch basins and stuff like that. but the 20 feet of trees, they said they were going to leave up. And that those 20 feet of trees didn't need to be touched. So what I was wondering is if you guys can support us in having them come in a little early and start and replant those trees that they mistakenly cut down, so that we're not having the continual flooding on our property and the dirt that could be stopped by the trees coming straight into our yard and causing problems there. I don't know if that's something you guys can do, but if that can be somehow part of your notes so that, you know, I know, like I said, Kat's been very cooperative, or Miss Lyons has been very cooperative. If she can also take that back to the people that she works with and say, look, you know, this is a serious concern, and you know, is that something that you guys can do, or is that completely up to Leoterra?
You said you brought some pictures with you?
I have the only picture I have, because I didn't know that I was going to be allowed to speak tonight. The only picture I have is my drainage ditch that has been filled up with dirt that is right now, well, right now it's not a problem, but when there's a big storm, it fills up with dirt. And the picture I took was it has filled up so much that it was only about 2 inches below where our drain, the French drain coming out from underneath our house dumps into that. And then, you know, I know that also continues down, and the neighbor across the street from us, I believe her address is 635. I'm not sure. She said that she's been having a lot more flooding in the last little bit too. Her backyard floods like crazy, and she couldn't make it tonight because she's out of town, but you know, that's also a problem. The flooding is also a problem for her on her property.
Any questions from the board for Ms. McKinney?
Ms. McKinney, sorry to interrupt. You sent me the email of the picture, right? Didn't you?
Oh, yeah.
Do you want me to try
I've
and
sent,
pull it up?
that'd be great. I've sent
What's your email again?
LMARYN1@yahoo.com. It's LMaryN1@yahoo.com. And it would just be a request to start planting that buffer zone, especially where the trees were mistakenly cut down, so that those can start to grow, and we're not waiting till the project is done before they come in and plant that back. Because that's what several people have told me, that's more than likely what's going to happen, is that they're going to wait till all those houses are done being built until they plant those trees back.
How long has it been since those trees were cut?
Couple months. And we've lived there 8 years, and I've never had problems with it flooding up until the last couple months.
Having trouble finding it.
I can send it to you real quick if you'd like.
Ms. McKinney, you said that over the past 8 years, you've not had any flooding under the house?
No, in the filling up of the ditch. The ditch has never filled up with dirt and debris
Before now?
before the last couple months, yeah. Because the ditch is about this deep. And it's always just, it's been deep enough where all the water has just gone on through down under the street. But the picture that Cameron's trying to pull up right now, it filled up all but about this deep of it. And it was right to the bottom of the pipe that was going to be then backing up into the house. Does that make sense? So it filled up about this much in dirt and debris. Now, about a week later, we had a big old gully washer, you know, and it washed out the gully. So in this case, we were fortunate because it did wash most of it out. It still is about halfway filled up with the debris. But it's not, right now, it's not causing a problem to go up under the house, but that doesn't guarantee that the next big storm, it won't fill up again, because it's filled up and then drained out and filled up and drained out twice now. So, and now it's about halfway full.
Any further questions from Ms. Kenny at this time?
Sorry, I'm having trouble trying to find this. I don't have anything from, or nothing searching up for the El Mary piece. Said L.
LMARYN1.
And nothing's even hitting on any of the folders in here. I remember getting it. I don't see it anywhere. Y'all continue to discuss, if I find it, I'll bring it up, but I'll continue looking through it for now.
And I can send it again. I have it
Please
on my
do,
phone.
if you want to do that, and make it a lot easier.
Is there anyone else from the audience who'd like to speak?
Hey, how are y'all? My name's Kevin Kreider. I live at 1727 Darrell Drive, about 3 lots down from the Tonewood that they want to close. I'd be for that. I just want to say the trees also behind our house were taken down, but I figured that they're doing it for construction and that they'll replace them. So that's the only 2 things that I came for tonight. Everything else is fine with me.
Any questions for Mr. Kleider? Thank you, Mr. Kleider.
May I speak again?
Well, actually, that's exactly what I was going to ask you to do.
Okay, sure. First, just wanted to thank the neighbors for coming up and giving their input. We do appreciate that. Mrs. Casham, Mrs. McKinney, and then Mr. Pryor. Thank you guys very much for your comments. As Ms. McKinney had indicated, we have had conversation. Our team at Leoterra is 100% cooperative, and we want to work with, we understand that it is an approved plan with a buffer that was to be disturbed and then replanted, but at the same time, we want to understand that this is disruptive to their home and to their property. And so we're going to continue to be cooperative with, making sure that we're limiting runoff as much as we possibly can. And then also get with our contractor on site to see what we can do to continue mitigating any problems that it may cause during the construction process. Generally, we know that in development that it does get a little messy before it gets better. And I do plan on having engineer record come up and talk about pre-construction drainage versus post-construction drainage and how like long-term it will affect the surrounding properties. But regardless of that, that's not now, that's years down the road. And so do just want to, clarify that on the record, we're going to do what we can to mitigate it's going to be a disturbance, but we're going to try to make it as minimally disturbing as possible. And like Ms. McKinney indicated, we've had multiple conversations and we'll continue to have those conversations and do what Leoterra can do to to be as minimally as disruptive as possible. So but thank you for your comments. And I'll have Vince come up. Yes, sir.
Excuse me. Is there a change in the turnaround on Archer from the initial plat, from the last plat?
The turnaround, I'm sorry, sir, what was your name? I apologize that this gentleman brought up previously, that turnaround that you're talking about?
The Ms. Cash.
Okay, I'm so sorry. At the end of Archer.
Right here, Kat.
Yes.
So is there a change between what you submitted the first time and this time?
I believe, yeah. Yeah, Vince can talk about it. I do believe he can go into the details. I do believe it was something that was required during the design process. We would be open to trying to help close up that buffer. But again, it's my understanding, Vince can speak to it more, that it was required by Graham. So, but we're willing to discuss it and see what we can do to close that up. Yeah.
Okay, you want me to talk about the turnaround first? Okay, that was required during construction plan review for a fire truck turnaround. A lot of municipalities recently adopted Appendix B, I think, of the fire code, and it has these humongous turnarounds, and that's what that is. If you want a smaller one, it would suit me to put a smaller one in there because we always used to get by with much smaller turnarounds, but that's the code nowadays for the humongous ones. So that's why that's there. I don't know how else to put it in there. Short of killing a lot, which I don't know if that would be a great thing to do, but okay, well, that's why it's there, is for fire truck turnaround and for maintenance vehicles to turn around in. It's a requirement by the city of Graham Engineering Department.
And it's large enough.
Yeah.
Yeah.
Yes, it is. You could land a small plane in there, I think.
Yeah. So it's a big one. That's what
Yeah.
I was asking.
Yeah, they're 120 feet across. Yeah. If you could convince your fire department to live with a smaller one, we'd be glad to put one in that's not quite so big.
I have a question for you, Cameron.
Yes, sir.
Are lots 85 and 86 recorded?
No.
No, sir. So you see where these hash lines are at? Those are all the areas that have been recorded under phase one right here. So it stops 78, 124, 133, 134. So this open space is still not, I guess, recorded on the plat, and everything over here is in either. So,
So 85 and 86 are not recorded yet.
correct. Yes, sir.
That's
Okay.
right.
And the buffer that was proposed in the initial zoning entitlement was a 30-foot undisturbed but vegetative buffer.
It was an evergreen.
Evergreen, yes, sir.
Yeah.
So there was no discussion, and if we go back to the previous plan as well, I think a lot of it was discussed as, I can find it somewhere on here. But it was more or less, yeah, you can hardly see it, but it's labeled here as 30-foot evergreen screen. I don't think there was any discussion that was ever brought up during the initial review of the planning board and city council back in 2021 associated with if they were going to be existing trees or not.
So
So it's the other end of Archer. Why you got that up there, please?
the Vince may know better than any of the rest of us. Was that proposed as just to be
Not in my,
planted?
not in my mind. It wasn't, in order to get the pads to fit, we had to put swales behind them, and it requires grading all the way to the property line in
I
most
see.
cases.
So the zoning entitlement did not call for an undisturbed buffer
No,
section.
there was no.
So
condition
eventually
for
it would
that.
be planted back in
That's
30
correct.
feet of
Yeah.
vegetation.
Yeah.
Okay.
And
that
it should
helps.
be maintained by the HOA, so it'll be, a decent looking buffer. It shouldn't just be a bunch of scraggly trees.
All right, Cameron, and a question for you and during staff review.
Yes,
So,
sir.
so the fire marshal and city fire inspector have both looked at this plan
Mhm.
and have endorsed the dead end turnaround and the hammerhead turnaround,
Yes, sir.
and have required the hammerhead turnaround to be at the end of the whatever street that,
Archer.
at
Archer.
the end of Archer, but not at the end of
Archer.
Hampton.
okay, so that's the only one. So,
sir.
and so it is remaining that 85 and 86 are not recorded.
Yes, sir.
And it is that the triangle number 2, which is off the screen now, to the bottom right-hand corner,
Yeah, I was trying to.
I would imagine that would be about a 50 to 60-foot right of way, correct?
Yeah, 50, because it matches up with the Tonewood Drive down here. Yes, sir.
So if we have a citizen that is in support of closing that or abandoning that connection, and we have a citizen that is concerned about the encroachment of the hammerhead into the 30-foot buffer, could we not take lot 85, put 85 in the void of triangle number 2 and slide that hammerhead back out of the buffer? It would be my understanding that if the town engineer were here, he would require the hammerhead to be the certain dimensions that Mr. Vince has designed, but not necessarily into the buffer. The buffer would be used to take the area needed for the hammerhead and not lose lot 85. So if we have lot number 2, we could move 85 to number 2. Cat would not lose a lot, and Mrs. Cashin would then have her 30-foot buffer back.
I
Is
think.
that something that you all discussed?
Nah, I mean, I think the main reason is, I mean, it even speaks to it in our street standards inside the development ordinance of dead end streets, right? And that dead end streets can only assume within like the minimum of a lot width. So say if the street was going to stub out right here and end at this 87, then yeah, it could stop. But our street standards also mention now that if it goes past an area, then a temporary or turnaround needs to be provided. And I think that is due to what the fire is requiring, because also trash trucks too, because you're having to take a trash truck down this road and there needs to be some area of turnaround so they can go back down, because they're not gonna back straight down the street.
Yeah, my concern is not whether it's required or not, it's whether it can be moved 20 feet to the south, take lot 85, occupy number 2, resulting in the same net, but both citizens in the adjoining properties are satisfied.
According to what the technical review committee has reviewed and engineering and fire has looked at, I mean, I think that this was their understanding that this was adequate upon discussion with Vince and other members of the TRC. If you want to propose a condition that associates with that, then that'd be something that we would carry on to city council and we'd review at the city or the TRC level after approval, if approved. Yes, sir.
May I
He
speak?
wants to make a comment to that.
Yeah, just what Chad suggested or Mr. Huffine suggested is a good idea. I can do a one-sided turnaround, then pull it back 60 feet from the end of the street and get it out of the buffer. The only problem is that that area is only 50 feet wide and our lots are 52 or 3, so I might have to shift things around a little bit to get the lot width I need. I'd almost rather put it in the kiosk area of the common area of the cul-de-sac, further down Carter Daniels Drive. Can you pan over a little bit, Cameron,
Yes, sir.
to the, yeah,
Back over
where
here.
that number 3 is? I could easily put a lot there.
That storm drainage easement south of 172 is set already. So in your design, it's already set.
What's that? There's
That
no
big piece-
lot
That big
between,
piece of storm drainage that's running adjacent to 172 it's fixed in your
Oh.
design. If you,
go ahead.
Okay.
What would you rather? Yeah. Yeah, I'm not sure what.
Yeah,
It's-
it's
that's
hard
the
of,
same
hard
as
of
this.
hearing, so I'll just go ahead and say it. Yeah, Mr. Huffine, I think that's a great idea. We had explored, adding that lot on Tonewood, but because of the width restrictions, that's not gonna work. But if we can fit a lot on, in that area designated 3, in that cul-de-sac, if the board is agreeable to that, we'd be more than happy to swap 85 to back off that
Right.
turnaround a little bit, and close off the buffer and move the lot to the previous kiosk location. That would also require approval from the board though, because it would be another amendment to the site plan.
Mr. Chair, question, comment.
Sure. Go ahead, Mr. Wood.
We've got a request for an approved plan and changes to the approved plan. I feel like our discussion is going awry. What I'm hearing are legitimate concerns and they should be expressed. I'm not sure at this point, that's what we need to be discussing. It should be discussing the request as presented. Or is it appropriate to add additional conditions at this time? I would say at this point that we need to address what the request is as presented and then hear these other concerns at another time, maybe in public comments or whatever. They are legitimate. They need to be heard.
Well, generally,
what I'm saying.
it is my position to understand that if you're going to put conditions on particular property, that the conditions that they're asking for, you can also, from the board standpoint, add or take away conditions considered.
Yeah, I understand that, but what we're looking at is an already approved plan. And they're asking for variances to that plan. Changes to those parameters. Do we need to address that?
Would you like to
And then
comment on that,
address-
Mr. Cameron?
I will
That's
note
separate.
that, and I reiterated and relayed this over to the developers as well, but once the conditional rezoning request is opened back up, everything is susceptible to conditions outside of probably what has already been platted out there. So to Mr. Huffine's point, asking whether or not 85 and 86 have been platted, the whole area that's not been platted is pretty much up for grabs for any aspect of conditions that you all may recommend to city council. And I'll reiterate that again. I mean, everything here is recommended over there as well. So good recommendations, but like I said, it's all kind of free game at this point outside of what's already been platted.
So
So
you're saying at this point that anything that comes up in the discussion, public hearing can be addressed in this meeting at this time? Is that what you're saying?
I can say that you can add conditions to recommend to city council based on what you have heard tonight. Yes, sir.
I think it's appropriate to do that.
Thank you for that clarification.
I think it's appropriate to be looking at the question we're asking. Because the plan that's being presented before us does have some themes and variations, notably this hammerhead turnaround, which was not on a previous plot. We also have a citizen who's got concerns about it. And we've got a developer who's willing to jump in and add a possible solution.
If I were going to make a suggestion at this point, I would suggest we address what's here in the request. And then the developer get with the neighbors, the residents, work out whatever is going to be needed or requested from them and come back to us again. with a-
Could I-
Can I,
that-
sorry, Mr.
Does that make any sense?
I'll have two points of, I guess, emphasis is if this is something you all are wanting to discuss as a board, and all the public time, everybody's public comments have been assessed, then maybe it'd be nice to close the public hearing and then start discussing it amongst yourselves as to what you all want to do with this. As for the variations, as you mentioned, Mr. Bias, in regards to the plan, a lot of what is associated with these conditional rezoning approvals, these site plan city council approvals, they are also subject to the technical review committee approval. And so you mentioned how the previous plan doesn't show a hammerhead right here. It's because the technical review committee at the time had only reviewed this phase one part of it. So before they submitted this request for the amendment to the rezoning, they submitted their site plan and construction drawings for phase 2 and 3, to where the technical review committee got time to comment on, I guess, the extra requirements, and that being coming from fire and engineering and possibly even public works of this extended stub out T hammerhead area, due to the fact of making sure that, trash trucks, fire trucks, EMS could get down these lots and make a turn and come back around and not have to back straight out. Because that'll cause many issues. I guess you imagine a trash truck or a fire truck having to come down, like 200 feet of road backing straight up. That's what they'd rather them turn in, come back down. So that is what the requirement from the technical review committee was on this stub out right here. So yes, sometimes a little bit stuff does come up, but it comes from the technical review committee side. And there are minor administrative amendments that we can approve. And there are things like the fire requirements that come into play where those are required per code, and it doesn't change the whole aspect of the plan. So that's all I have. Sorry.
Mr. Chairman, sir, may I please make a suggestion?
Well, certainly, yes, ma'am.
I would love to ask the board two things that are coinciding. One would be to, as Mr. Bias was indicating, go ahead and Mr. Wooten was indicating, go ahead and make a decision on the revisions that we have provided today. And then also see if we can add a condition in accordance with what Mr. Huffine has referenced in adjusting the location of the turnaround a little bit and switching the location of lot 85. So revising, approving the revisions that we have brought up today, and then adding the condition of relocating lot 85. Would love it if the board would consider that, or, oh, sorry, 86.
Very well put, Ms. Lyons. Thank you very much for that.
Yeah, 85.
Is there anyone else that wants to speak? If not, I'm going to ask for a motion to close the.
Chair Benesh,
Yes.
Kat, do you have anything else?
I think Mr. Huffine had a thought there.
Oh, I'm sorry, I did not hear.
I'd
you.
ensure that all the public is done comment on it as well before you close. I think there's somebody else that'd like to
Oh,
speak.
there is?
Yes, sir.
I'm sorry.
Let,
What,
if you want to come up and state your name.
yes,
and
ma'am,
address, yes.
please, come state your name and address, please, for the record.
Quick, I am Demetrius Curtis, and my husband and I, George, live at 614 Rockwood Drive. Right now, our saving grace has been the 30-foot buffer behind us. And we hope that's going to remain. Am I to understand that it's going to take 10 feet away possibly?
Yes, ma'am. So the discussions with, neighboring property owners, when the site plan was approved, it was not approved as an undisturbed buffer. However, so that means that we are allowed to disturb it per plan. However, we are going to limit the disturbance of that buffer as much as possible until we absolutely have to. As Mr. Townsend was explaining, there is some grading, so we have to move some of the dirt right up to the property line. So there will eventually be disturbance, but we are going to wait as long as we can to disturb it so that those trees remain up as long as they can.
Okay. Right now, they're really mature, really nice existing pine trees on that were pre-planted, you know.
Yes, ma'am.
So.
Ms. Curtis, please direct questions here and,
Okay, yes, I was just wondering if they were, the existing mature pine trees will remain there rather than, clear cutting and then, replanting. Is that something?
with what is, they could disturb the whole buffer if they had to, as long as they put it back, is what I understand, correct?
So so what you're seeing on here is what they are going to be required to put back in is that 30-foot evergreen buffer. As Kat mentioned, I believe they do have the authority to grade to the lot line as it stands, but I think she noted that they were going to leave a 10-foot little buffer area, if I'm speaking correctly, to, I guess, not be doing everything up to the lot line. But before they pick up all their construction equipment and move on out, when every house is built, there will be a 30-foot evergreen planting in that area, or they will not receive their letter of credit back from the city of Graham, or their surety or their bond, whichever one it may be. So there are things put in place to where these things are going to be required to be placed.
All right, well, my concern would be the trees are already there and they're mature,
And
rather than to have to go back and replant. And, it's gonna take years. for
yes,
them.
ma'am. And as
Right now, we've got a really nice adequate buffer that, really
Yes, ma'am.
gives us a lot of more privacy as it is right now. And it would be years for, new trees to mature to
Yes, ma'am.
the way they are now, so.
And I understand as well, but in the approval back in 2021, there was never any decision made to retain any of the existing trees out there. They just described it as a 30-foot evergreen buffer. And I think the intention was to leave 30 foot of the existing trees out there, but it just so happened that it didn't work that way. And once you, I guess, start ripping the Band-Aid off, you got to go ahead and rip it all off. So I think that's what eventually happened. And if Kat wants to come back up here and speak to it, she definitely can. But I think from my understanding that things are going to be planted back out there. And it is unfortunate that, the mature trees may go away. But it was just never mentioned on the original approved plan out there. So we have no safeguard, I guess, for that area.
Okay, well, that would be a shame.
And you said you live on Rockwood, correct?
Yeah,
So you're back.
614.
Yeah. I don't know if they have any plans on leaving existing. I don't know if this bubbled out area is the existing area that they're not gonna touch. I mean, they do have floodway area coming through here. So, I mean, are these bubbles right here? Are these existing ones right here that you aren't gonna mess with? Okay, so all of this bubbling in right here is where the tree line's gonna maintain. So if you're back over here on this area, what they're referring to me as, if I'm correct, that this tree line will retain itself, correct?
That would say. Okay,
So if you back here, you might still retain that natural buffer.
all right, right now, there's the curtain is back there. Right? It looks like it was stopping at that point. Okay, all right. Well, that was my concern. Thank you.
Yes, ma'am. Thank you.
Thank you. Is there anyone else from the public that'd like to speak at this time?
Yes, ma'am.
Yes, ma'am.
So, we're still talking about this turnaround and they're willing to work, but you're saying you're not going to vote on it now? Is that what, but I'm understanding, okay, I was never notified from the original plan that for the plan of phase one. I never understood that. So I had no say-so in when they changed things around in phase one and it was approved.
So,
Okay, so,
okay.
but now I understand you're doing 2 and 3 and things have also been changed from the original plan, some, but not as much as from phase one.
Mhm.
Okay, so so I don't understand why we can't go ahead and vote on that turnaround being like they agreed that they would go ahead and work with us to try to get it out of the buffer.
And what was stated to us is we will discuss the conditions that they've requested, plus any conditions that we may add to this proposal. And the applicant, Ms. Lyons, has already agreed that we could add those conditions and she would have no problem with that.
Good, thank you for the clarification.
I think another point of clarification, because you're asking about approval tonight, right? So this moved forward to next month at the city council meeting. Yes, ma'am. So this is a recommending board, so they will recommend the conditions they have discussed tonight at the city council meeting. And of course, it is requested by all of you that if you have any more complaints or you want to voice your concerns again, that you come back to the city council meeting as well, on the 8th of August, I believe. Yep. At 6 o'clock.
Is one turnaround efficient?
Ma'am, you'll have to come to the mic. I can't hear you. I'm sorry.
Is one turnaround sufficient for that large of a development?
Well, I would have to
I
refer.
mean, that's up to
Well,
y'all. I just
as you
want-
can tell, they also have 2 additional turnarounds in the form of cul-de-sacs.
Okay.
3 additional, 1 in phase 1 and 2 back here at the end property. So you
Okay,
have
those are-
turnarounds back through there and there. And like I mentioned, a lot of it is due with, I guess, citizen safety and trash pickup and ensuring that every lot through here can be serviced if need be and not having an issue getting in and out.
Thank you.
Yes, ma'am.
Is there anyone else that wants to speak?
Chairman, may I ask Kat to come back up and answer? a
Aaron.
quick question?
Yes, sir. Ms. Lyons, would you like to come back up, please?
Yes, sir.
Ms. Lyons, in the southeastern corner, along the parallel to the Rockwood
Okay.
Drive, specifically along the back of Miss Curtis's home. It appears that most of that is going to be either disturbed but not lighted out or put back in some way, so that is going to remain vacant once the development's finished.
Yeah, I don't believe it is designated. Is that open space that it's designated as? Yeah, so it's designated as open space, so we don't have specific plans other than designating it as that.
So it may be valuable for Ms. Curtis to hear that there won't be any homes proposed back there.
Yes,
At
no,
some point, it's going to be woods again, and
yes, sir.
yes, ma'am.
The third lot.
Yes, sir. There will never be any lots back there. There will never be any structures or, yeah, it will be grass or wooded area.
And then a follow-up question, does it harm you in any way in your mind or in Mr. Vince's mind that if we were able to move the Hammerhead out of the buffer and find an additional 1 or maybe 2 lots, that would be a condition that we could possibly consider tonight and move forward?
We would absolutely be open to that condition. I think we would ask for some verbiage that is lenient there from the board, just because we're not sure which lot makes the most sense, but as long as we're able to relocate for that purpose, we would love that verbiage in the condition. Because obviously, Mr. Townsend doesn't have his, AutoCAD file out right now, able to accurately measure everything, but we would love for just a little bit of leniency on where that lot can go.
And then one final question for Ms. McKinney's benefit, does the property slope to the west towards her lot from lot 92? And is there anything we can do to berm that during construction to?
Yeah, we're willing to do whatever we can to, obviously we have to grade out the lot so that we have an appropriate size building pad that meets the appropriate slopes and compaction standards. But after that, we're willing to do whatever we can to minimize and mitigate the disturbance.
Do you know if there's a diversion proposed there for the erosion?
And while Mr. Townsend's coming up as well, I completely forgot to, what Ms. McKinney was showing earlier. This is the picture she sent over to me in her lot area.
So was that on us or off? Is that on the project site or is that off the project site?
Yeah, is that black corrugated pipe coming from our site?
No, that's coming from our crawl space.
Oh.
That's the drainage pipe that
Oh.
pulls the flooding out under the house into that ditch. And the water was just about 2 inches below the bottom of that pipe. So and that drainage ditch is on our.
I can explain the drainage that we have proposed if you pull that plan back up again.
Yes, sir.
Can you zoom in on the area between the cul-de-sac and the hammerhead? There's a lot of, well, as you know, or Chad knows, and probably the rest of you do, we have to capture the runoff from our impervious surfaces and treat it in these permanent wet detention ponds. So when we're finished, all the runoff from our lots will make its way to the SCMB in the very bottom right of that screen you see there. And during construction, I know I have a temporary diversion berm that runs along that entire property line. So there shouldn't be any water running out of our site into Miss McKinney's property, but it sounds to me like perhaps there is. Anyway, is that clear enough for how the drainage is going to work? When we're finished, there won't be any water running from our site onto Miss McKinney's property, not from the houses.
The gentleman I talked to yesterday, you'll have to remind me. Gerardo, I believe is who it was, said that the drainage ditch goes part way to our property, but doesn't continue all the way to the property. So it's on the western side, I'm sorry, the eastern side of the property, heading towards us, but it stops before it gets to our property. That makes sense. Is what he was telling me. That he said that at some point he was going to try to continue it past our property up into the existing stuff that's already being built. Does that make sense?
Yes, ma'am.
I'd like to entertain a motion to close the public hearing.
So move.
I'd like to make a motion that we close the public hearing.
I hear a second.
I'll second that.
All in favor?
Aye.
All opposed? No discussion between the board members. Any discussion? Questions, comments?
Yes.
Woody?
I'm hearing a lot of concerns, different issues, turnaround, drainage, berms, buffers, all these things. I'm still of the opinion that we need to deal just with the request as it stands tonight. And I'm also hearing a very strong willingness from the developer to meet with the people and address these issues. I think they should take the time. I would suggest that we not do anything on the fly tonight. Doing things on the fly this quickly never leads to good outcomes. So I'm of the opinion that they need to get together, discuss these issues, bring them back to us, and work out that first, so we're not going back and forth all night. I think what we have here as the proposal, it stands. I have no problem with that. Minor changes for an approved plan. I think we should go ahead and approve what's there. But as far as adding any other conditions tonight, no. But the concerns are legitimate. They need to be addressed and heard. And I think in a venue that's more relaxed and not time constrained as this evening.
Mr. Wood, when you're referring to approving it tonight, right, or recommending approval tonight, are you saying just like conditionally in a sense that, okay, we're all right with this, but you need to bring something else because
No,
if you recommend approval, it has to move forward to city council. So you'd then be.
all I am
tabling it.
recommending in my,
Yes, sir.
what I'm saying is what you have presented to us, staff report.
Mhm.
Just recommending approval or disapproval for those items. And then suggesting to the folks, the neighbors, whoever's involved, the developers, that they need to get together and work out some of these things and come back to us at a later time. That's just a suggestion.
Yes, sir. I guess the issue with that is once you recommend approval with anything associated with the conditional rezoning, it moves straight forward to city council. So if we recommend approval on what was done tonight, what they then could do would be hash out all the issues that they had, present a new site plan to city council. But then again, at the same time, they're presenting a new site plan based on no conditions associated from the planning board. So the conditions that were heard from the city folk tonight would then be incorporated on a site plan shown at city council. Does that kind of make sense?
No, no. What I'm saying is that sometime in the future, at another planning board meeting, they can come back with a request, just like they came to us tonight. We'd like to make these changes.
Mhm. So
And we discuss it just like we did tonight.
you're requesting they get you,
I'm suggesting.
yes, sir. You're suggesting that they get their recommend approval from you all tonight for the conditions that are listed.
That's
Go to
correct.
city council. Hear if they get approval or denial from there, and then come back 2 months from now to you all with an updated plan to go back in front of city council. Is that correct?
That's correct.
Just making sure I was clear.
Mr. Chairman, may I ask a question?
Well, why certainly, sir.
If we approve tonight just what's on the table and they go to city council and get approval, there's no requirement for them to come back to us. Is that correct?
Unless there would be no requirement to come back to you all under any other conditions. So if they came to, so say you recommended approval based on the conditions that say, they said for the 1, 2, 3, the open space, the kiosk and the removal, city council then approved that exact same condition, they could easily just say, all right, we're not doing any of the other stuff. Because as I believe somebody mentioned, there's no leverage associated with that.
So our best option would be to table tonight at best if we want them to consider these others.
Or associate them with conditions. So if you think that what you have on the table is the 3 conditions that were proposed, and basically the only other one that's been up for discussion, right, is the turnaround.
Right.
And basically the condition would look like engineering the turnaround in a way that blah, blah, blah. I think Chad could probably make the motion for that condition or write that condition out the best way. But tabling it due to that, I don't know if that would be the, I guess, a proper way of moving it forward. I mean, you can certainly, but I think that those are the 3 that they are proposed, and the one that you all have discussed the most about was the turnaround area. And so if you can figure out verbiage for the turnaround area, then you got 4 conditions moving forward to city council, if that kind of makes sense.
It makes a lot of sense from the standpoint that it's a conditional rezoning. They came here with certain conditions and asking for approval of the board, and then we add any conditions that we deem necessary. And we talked to the developer and along Ms. Lyons. And she was very open to the fact of the other condition, actually suggested that we approve it in tonight's proposal.
Yes, sir. I think the only thing that you all are missing right now is a motion with the conditions you all have, unless y'all want to have more
That
discussion.
is correct.
Mr. Chairman, I do have one more question.
Certainly, Mr. Stocker.
Do we need to state in the motion that the previous conditions are retained?
I would suggest to do that. Yes, sir. So the previous approved conditions. So I guess if you wanted to sit here and word it out right, so make a motion, blah, 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 to approve based on the previous conditions of the approval in 2021. The 3 conditions that were proposed and the additional condition of the turnaround area redevelopment. Or you don't have to give the date of the approval, just say previous approval, previous approved conditional rezoning plan.
Mr. Bias, you,
I am of the mind that we go with the 4 conditions that have been suggested so far. And that the 4th one of the turnaround be worded so that the applicant can work with the residents and the city staff to find a good workable solution.
I think Mr. Hines could put that in verbiage. Mr. Bailey,
I'm with approval for the 4 conditions. There were 3 plus the turnaround.
And ensure, as Mr. Stockard said, to include those previous conditions.
yes, he
The
did.
previous,
Mr. Huffines.
he's working. on
You gotta write these things out to make sure you say. them
He
right.
is writing as we speak.
Yes, sir.
And I believe I'm gonna ask for a motion when you complete it, sir.
Cameron, what time did the air conditioning cut off?
The hairdresser cut off?
The air conditioning.
Oh, air conditioner. I was like, I know a lot of people give me a hard time about my hair too. It's been a little, it's been a little bit warm in here. I can't remember what Chair Ward always, either it was too cold in here, right? Or it was too warm. So one of the two, I can't remember, but I guess about after 5 o'clock, when nobody else is in here, they cut everything off to save energy. You know, we gotta get as much money as we can here at the city, so.
How long have we been having this meeting at this time?
Hey, that's
Look
what happens.
here,
If
we'll do
if
that
it had just
and
been
then-
one board, but we had 2 and very 2 extensive discussions with both of them, so. You know. I haven't received, I mean, we got 7 more days.
Would like to ask for a motion with all conditions, if any.
Mr. Chairman, I'd like to make a motion to approve the plan with the previously held conditions as approved in the 2021 conditional rezoning case with the following conditions. Condition number 1, the turnaround, hammerhead turnaround at the end of Archer
Yes.
be located further inland and outside of the 30-foot buffer. That the developer have the flexibility to increase from 1 to 3 additional lots somewhere on the property, specifically looking at the abandoned or removed right-of-way in triangle area number 2 as marked on the submittal. And then a third condition, I'm gonna have to pause because I think we got them all.
Triangle.
Did we miss one?
Did we miss one? Or was there one we wanted to do
The
in?
mail kiosk.
That's already there.
Oh, so when you talked about the previously held conditions, you were talking about the ones that they proposed here tonight as well.
Correct. They have an existing approval.
Yes, sir.
They have conditions that are already being asked for. In addition to those conditions, we have 2 additional ones, one to move the turnaround out of the landscape buffer. And the other one is to allow the developer to have flexibility to find from 1 to 3 additional lots, it appears, in the areas that are lost to or not being used in the mail kiosks, triangle number 2 and number 3.
Yes, sir.
The closing off the street and the turnaround and the getting rid of the mail kiosk.
They should already be in the conditions, I think.
Well, so I think, you know, and sorry to kind of keep this rolling on, but it's not specifically said, I guess. They come here with conditions, but just because we don't specifically note them or I think it's better to be said out loud rather than referring to, okay, they showed it on the plan and it's known. rather
Okay, I'd
than
like to make another motion, Cameron, if I
Sorry,
may.
I apologize.
Okay, I'd like to make a motion to approve the plan as submitted. In addition to the existing zoning approval they received in 2021 with the following conditions. The number of mail kiosks be reduced from 3 to 1 as required by the U.S. Postal Service. The dead end at Archer be changed to a hammerhead turnaround in conformity with fire code, with the provision to locate that hammerhead further inland of the project and outside of the 30-foot buffer, which was previously purported to be included in the conditional zoning I would like to add the condition that the developer be allowed to increase the number of lots they show from 1 to 3 by taking advantage of the removed mail kiosks. And that the lot, 85, be included in that 1 to 3 lots such that the hammerhead could be moved out of the buffer. And are there any other?
Goes off the street.
Tomewood Court.
And Tomewood Court, the proposal would include a condition that the Tomewood Court triangle number 2 be removed from the plan.
It all conforms. 2035 plan.
I'd like to second that.
I have a motion on the floor with conditions submitted by Mr. Huffines. Do I have a second?
I second it.
All in favor?
Aye.
All opposed? Motion carries with conditions.
Excuse me, Mr. Chairman. Can I get a,
All
clar-
opposed?
can I get a clarification on the vote?
I can poll, sir. Mr. Bailey,
Aye.
Mr. Wooten.
Aye.
Mr. Huffines,
Aye.
Mr. Bias,
Aye.
Mr. Stockard,
Aye.
and myself. Aye.
If I may, Chairman. The one item in question with Ms. McKinney and Ms. Lyons, the offsite deposition of sediment, that's for another location and not under the purview of the planning board, but it appears that you all have a relationship that'll take care of that after the meeting.
Is there any public comment on non-agenda items? Or any items not on the agenda? Would anybody like to come forward and discuss? If not, I move for an adjournment. I hear a motion to adjourn.
I would like to make a motion to adjourn.
I'll second.
I have a motion and a second to adjourn. All in favor, say aye.
Aye.
Meeting's adjourned.